Yes, Your Honor, it was 0.133.
What else? Anything else?
No, just alcohol, Your Honor.
Because there was marijuana in the car.
Yes, we only tested it for alcohol. The DPS, the way that it works is if they test over 0.08 for alcohol, we do not test
They
it for
just
drugs.
drop it.
Yes.
Hmm. All right. You're still at 10333 Clay Road?
Sir.
Where do you live, sir?
431 Orange Avenue,
431.
Orange Avenue, Port Arthur, Texas.
There's an Orange Avenue in Port Arthur.
Yes.
That's 77640, right? What's his zip over there? So that's
77640.
are you employed somewhere? Oh, is Langston Adams your attorney?
Well, no, I'm on initial designation, initial designation. I think,
Are you
Another condition.
Are you retained?
no, sir,
Oh, okay.
no, sir.
Are you working somewhere?
Yes,
Where?
back from, I just, been off work for a week. I was sick. I would like to ask, request to give him a paid lawyer. If that's fine.
Who have you talked to?
Jay Hona. Out in Houston,
Oh, okay. So where are you working though?
Bethel,
Like, how much do you make an hour there?
30.
You're gonna hire your own lawyer.
Yes, sir.
Yeah. Yeah. That's. How much time do you need to do that?
Weeks. 2 weeks.
2?
2 weeks, yes, sir.
You got 3. 3. You got 3.
Yes, thank you.
Oh.
Yeah.
Do you understand you're charged with the state jail felony of operating a motor vehicle while intoxicated with a child under 15 years of age? If it would have just been DWI, it wouldn't have been a felony. But because there's a child involved in the vehicle who is at risk, it's a state jail felony, which carries with it up to 2 years in the state jail. Do you understand? Mr. Adams is going to continue to represent you until you can get somebody hired. If you need to get some advice, you call him. He's standing by if it's needed. But it sounds like you got a plan, so.
Great.
That's what we'll do. We'll set it with 3 weeks. Get a resetting and also just have a seat in there in the box before you leave. We're gonna test you to make sure that there's no alcohol or drugs.
Right one, Chris? Right one? Right there.
Okay, Derek Robinson
Think it up one more time. One more time.
is called next. 18-30830.
Reconcile it there for the highlighted X's. There's that. And you'll have to write it.
Okay. Are you Derek Robinson?
Yes, sir.
Are you still at 10776 Gage Road,
Yes, sir.
Beaumont? You're charged here with the state jail felony of illegal possession of synthetic marijuana. And that carries with it up to 2 years in the state jail. Are you retained? Oh,
I'm appointed on it.
no, okay, where do you work when you're not
He's-
hauling drugs around?
I'm just currently getting out, so I'm not working here.
Hmm?
Just currently getting out. I did 7 years. And
Wait, 7 years in prison?
yes, sir.
How long have you been out?
Like about 2 months left.
And you get arrested for drugs?
No, it's old.
This was actually, it looks like from 2018, Your Honor.
It is 6 years old. They just never did anything because you've been in prison?
Yes, sir.
What were you in prison for again?
Family violence.
For 7 years for family violence?
7 years.
That's not the way it works. I do this every day. You just don't get it from family violence. You must have been charged with aggravated assault. Pull him out. Is it from Jefferson County? This is, you don't get 7 years. How many convictions do you have? Do you have other convictions? Did they stack them together?
No, it was enhancement.
What do you mean?
Uh,
Enhancement
It was enhancement. It was
because of a prior conviction?
yes.
Okay, so you had a conviction before a felony convictions which made you weren't allowed to get probation from a jury.
Yes.
What was your conviction for before?
It was for family violence.
For family violence. Oh. And then you get charged with another family violence charge? Were you on probation at the time
First one, yes, sir.
for the first one? And then you committed another one while you were on probation?
Yes, sir. And they,
Was it in this court?
and they enhanced it.
Oh, that's what I do. The print that out so I can see it, please. So what's your status of work? You're not working?
No, I'm currently looking.
And Judge, I think I can move this case today.
Yeah. Here's something that's got to be moved today, and that is he did not fill out. There's no indigent form here that needs to be filled out
Right.
before we dispose of the case.
So just put that on the phone. No, we try to move it today.
I guess, yes. Then you read them on.
Had a hold. Look at this. Look at that. Signed, it's initialed by the JP, but nothing's filled in, and then it's. You want me to tell in front of everybody?
No.
You look at it. You gotta fill that part out. It looks like somebody initialed for the justice of the peace without it being filled out, which is improper.
Yes, sir.
You just can't make this stuff up. It's like night court. All right, it needs to be filled out. But
All right, we'll try. No, this. I'm trying to take it. This, I'm trying to take it right now, today. Hey, Larry. So we got.
hey,
Filling it out.
hey, Mr. Robinson, that was a jury trial.
Yes, sir.
Oh, okay. No, that's why you got 7 years. Yeah, you went for the 4 juries and you had a prior conviction. And juries just don't tolerate that. They shouldn't. We need to get the, I need to get this thing two hole punch when we have time to, because I want it part of the file. Zane Buring, please, done. Twenty-five CR 198, Zane Buring.
He's right here.
Maybe he is, maybe he's not.
Wasn't once before. Okay.
Yeah. That's you, sir?
Yes, sir.
Okay, what's your address? Is it still 365?
No, I
Good.
had moved to Austin.
Everybody's moved. What is it now?
412 East William Cannon.
What?
412 East William Cannon.
East William Cannon.
Austin, Texas, yes, sir. East William Cannon.
What is the zip?
I believe 787.
Yeah, speak up.
I believe 78745.
How long have you lived there?
For the past year.
For the past year and you don't know your zip code?
I never use it last time.
You never use it?
No, sir.
It comes in handy when you write a letter
I haven't wrote a letter in a long time.
or paid a bill.
Sir,
You pay bills, don't you?
I pay the person that owns the stuff.
Oh, you're renting there?
Yeah, I'm just.
Oh, okay. All right. Yeah. Did you get your driver's license changed?
No, sir. I haven't had a chance to be able to get my.
How long have you been there?
I'm just doing my yes.
A year? That's no excuse. That's not, the state doesn't put up with that. What do you have, 60 days? 60 days, something like that. That's all, days, not a year.
Boy.
You don't have a driver's license?
No, sir.
Well, how do you get around? Do you walk?
My dad brought me there.
Okay. But you don't operate a motor vehicle? But you still have to have a state ID of some sort.
Yeah, I haven't been over to get mine.
I don't know.
Who's the landlord there?
His name is Chris Davis.
Okay, friend, acquaintance. All right, now, let's get to
Thank you.
the meat, the guts of this one. You're charged with what's called engaging in organized criminal activity, which in summary, you and others collaborated in, according to the grand jury, in carrying on a criminal activity which involved illegal possession of a controlled substance and possession of dangerous drugs and illegal possession of marijuana. You understand what you're charged with? And this, the way this has been indicted, this is a first-degree felony if convicted. You're facing life in prison if convicted. Do you understand?
Yes, sir.
What happened was the way the probable cause affidavit is, y'all had a large-scale drug operation going on Homer Drive in Beaumont. And people convicted of such a thing we're talking about pounds of drugs. They end up paying a steep price. All right.
For roughly 4 weeks. It's a brand new case. Yeah, I just met this morning.
You're unable to hire a lawyer? Is that right?
I'm trying to obtain.
Are you able to, where are you working right now?
Right, I work at a recording studio and I'm also a student.
How much do you make an hour?
12 every year.
You know,
12.
well,
12.
yeah, that's like 20 grand. You're, but for a first degree felony, an attorney's gonna cost that. At least. Fill out an indigent form. Get over there, fill that out, an indigent form. And that's to be completed, so Mr. Dusler can continue to represent you. You can hire somebody anytime you wish. The taxpayers would love that, rather than paying for your mess. We would rather have you earn it and pay for messes, but until then, fill that out. We will go to the next step. DeMarcus Roy, Don, that's next. DeMarcus Roy, 25 CR 338. See, this is, you're DeMarcus Roy?
Yes.
Back in February, so we got March, April, May, 3 months have gone by. Back in February, you were arraigned in front of the magistrate for this second degree felony of assault on a peace officer, which also includes 2 prior convictions, 2016 robbery. And you were convicted in the court next door, the 252nd, also in the court next door. After that was final, you committed unlawful possession of a firearm by a felon and were convicted of that in 2019. Thereafter, it is alleged you committed this offense. I'm looking at this affidavit of indigence. And this was, you were in front of a magistrate 3 months ago. And do you remember what you told the magistrate? You're going to hire your own lawyer. That's why he didn't appoint. I know you didn't hire him. Who'd you hire? So are you lying to people? 3 months have gone by. You were supposed to hire somebody 3 months.
Yes, sir. I had the first finish paying off my bond, sir.
You don't have a plan in mind about how you're going to do things? You've made a promise to the magistrate that you didn't keep. Thanks for wasting all of our time and the people's time and money. So who are you going to hire now? You've had more than enough time. Who are you going to hire?
I need some more time.
No, you don't. You're not going to get it. We're not waiting on you. We're moving forward. You're an habitual felon. According to this, you're looking at a minimum of 25 years in prison, minimum to life. You know what that's going to cost? Do you?
No, sir.
Who have you talked to in 90 days?
Sir.
Who have you talked to? What attorneys have you talked to? No one. That's why we don't wait on you. We're moving forward. The whole idea is to trick people, mislead, deceive, whether it's a judge or anyone else. Stall. Maybe it'll go away. No. You got our devoted attention. You have got my attention. That's not what you want. Sit over there. We're going to deal with you and the other people who are taking care of their business. We can take care of them. Thomas Skinner. Come on out. 25 CR.19. You're Thomas Skinner?
Yes, sir. How you doing?
I'm fine. You got to be kidding me, right?
What's that?
That's what you wear?
I didn't have a clean shirt.
You don't have a clean shirt at all? I'm on the Salvation Army board. We got all kind of stuff for people, but you can't wear. I mean, would you wear that to church?
No.
Why not? Disrespectful? Would you say it was disrespectful for church? Well, you don't think court
I do
is,
apologize.
you don't think the Constitution is something that deserves respect?
I apologize.
You gotta do better than that.
I understand.
There's no excuse in this town. I mean, we're low.
Well, I live in Hampshire, it's still just.
You do a bit, we take care of people from Hampshire
I
too.
understand.
We can take care of
I
people
do
who can't.
apologize. Martin.
Yeah, I don't want to see that again.
Okay. Hope you will never see me again.
Look, everybody, yeah. You know, if I had $1 every time somebody said that, I hope that's true, but I'd be Donald Trump. If I had $1 for every time people said that. That just seems to be what everybody says, but I see him a few months later. In court,
Yeah.
over and over again. No way. And fix this. Have you ever been convicted of a felony before?
Yes.
What?
Child endangerment.
Is that it?
Yes, I believe so.
You don't know?
I'm sure there's one more. I can't remember what.
You
I've-
can't,
I
you
was
forgot a
convicted
felony
once.
conviction? You
I
forgot?
was on probation for 5 years. In 2010
Hold
for
on.
child endangerment, child abandonment.
Okay, was that regular probation or deferred?
It was deferred.
Okay, did you get revoked?
No.
Okay, you weren't convicted.
Okay.
You don't know that?
I was assuming I was.
Who said, how would? Well, you look into that. I don't think you're convicted if you were on deferred and it was not revoked,
Okay.
sir.
I'll look into that when I get out.
Is there anything else that you can't remember that you coming back to your mind?
That's all I can remember.
All right. I think if you would have had that prior conviction, what county was that?
Jefferson.
It would have showed up on the indictment
Okay.
and it's not.
Okay.
Well, you don't want to go around filling out job applications saying you were convicted if you want to. You're not gonna get a job,
Yes.
huh?
It was. a-
See, it was deferred and it's been dismissed.
You're welcome.
Okay, you're clear,
Okay. thank
except
you.
for this now.
Yes, sir.
See back over there.
All right. It's a state jail felony which carries with it up to 2 years in the state jail. All right, does the defendant who's here with his attorney, Mr. Deucer, waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about February 28, 2025 in Jefferson County, Texas, you committed a state jail felony of theft, which carries with it, if convicted, confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine up to $10,000 can be assessed. Do you understand what you're charged with?
Yes, sir.
Okay.
It's the worst thing ever made in history.
Right, well, that's what they do. I know. But it's just 20 months. That's not probably the most efficient one time. Anyways, probation advance.
Seen the block chisel. Cavemen used to use that. That's what they found. Okay. You understand what you're charged with here and
Yes,
the
sir.
punishment range applicable?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on deferred again,
Yes, Your Honor.
where you're. Santa has come to see you again.
Yes, Your Honor.
You're placed on deferred or unadjudicated probation, which, well, we saw how well that worked last time, kept him out of trouble. Or
15 years.
it's supposed to be forever. You're not supposed to commit.
I was trying to do something nice for a person.
And well, you owe $1,504 to the complainant. You understand?
What's that mean?
The complainant, the person who was victimized. You owe, that's what the loss is. It states restitution in the amount of $1,504.
Okay.
How soon could you pay that back?
I can pay, I don't have a job right now, but I have a girlfriend and she's helping me out. But I'm going today and trying to find a job. Take 6 months.
Because that's what I'll give you, 6 months to pay it back.
Okay.
But don't be bumming off your girlfriend, off your.
Well, I don't, I mean, I do try and find odd jobs.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty, sir?
Guilty.
Are you pleading guilty voluntarily?
Yes.
That is on your own free will
Yes.
and because you are guilty.
Yes, Your Honor.
I'm going to show you what's marked as State's Exhibit 1.
Can you show me what?
Here,
Right here, so you.
here. That thing. That, all of our pads are down except that one. The one we don't ever use, and we don't want to ever use, but we're stuck using it now.
Yes.
You can see why. It's an odd thing.
Terrible events.
Okay. You've seen State's Exhibit 1. Did you sign it voluntarily, understand it, discuss it with your attorney, or the contents all true, correct?
Yeah.
State's Exhibit 1 tendered into evidence without objection. Among other things, it states you were mentally competent to enter your plea of
Yes,
guilty.
sir.
It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to your jury trial and your rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer.
Yes, sir.
All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports away.
Yes.
I'm going to follow this agreement. And I'm going to find you pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted you to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on, you know what it is, deferred or unadjudicated probation. Chapter 4. There will be terms and conditions of probation that you need to follow so that you are not revoked and convicted.
Yes, sir.
The first thing, you will pay restitution in the amount of $1,504 to the complainant, the victim. That must be done within 6 months.
Yes, sir.
There will be other terms and conditions of probation which are normal and customary that the probation officer will go over with you in a minute. Make sure you follow those. If you fail, your probation can be revoked.
Yes, Your Honor. Thank you.
You're then be found guilty and then sentenced up to 2 years in the state jail.
Thank you, Your Honor. Not for your games.
No, you're just go over it. Let me sign this. And you're gonna go over all of this.
Just how long?
You do well, it can be shortened to a third.
Thank you.
Okay. Do you see that, ladies? Is it the green thing? Is it the green thing that is this different? This whole thing presented was.
Yes. Send it back to me. Yes, right. It's not holding a charge. So,
And look, here's the deal. Maybe pulls back.
Judge, you can use your other pen.
Yes.
I mean, it's a little short. It's different from the one.
Other stylus.
Yeah, I mean, do that. I think I'm using the other side. So, okay.
Yeah, stylus.
Jasmine Young, please. 25 CR 363. What are we going to do? What, say that again?
I've got a big replacement is the conflict. I was previously appointed to a co-defendant, Eddie Davis.
For how long, though?
Well,
Are you still representing him to this day?
no, sir, I'm not right now, but I was.
How long did you represent?
For
A good while? Oh,
It's been recent.
it was short, and you didn't have any thorough discussions. That may not have been a problem. So, what we're going to do is another attorney is going to, one of the other, are you able to hire somebody? You have to speak out so that you can hear this. Okay. Then, Says take home pay of $1,700 monthly. Where do you work?
Don't work there.
You don't work there anymore? All right, another of the public defenders is going to be appointed to represent you. I want you to come back in 2 weeks and we'll find out who that is so that they can start helping you in this case, okay? Thank you. Deanne, and I find good cause to release Mr. Dusler because of a conflict he's articulated. Deanna Preston, please, 24 CL 691. David Grove, Deanna Preston, please. That's you?
Yes, sir.
Mr. Grove is here representing you. This is an initial appearance. You are charged with the state jail felony theft, which carries with it up to 2 years in the state jail and a fine up to $10,000 can be assessed. What are we going to do today?
Judge, if we could ask to have it reset for about 4 weeks.
We said 4 weeks for an announcement. Okay, please get a resetting. Thank you. McConnell Williams is called next, 23 CR 2059.
Yeah, it's less than that, seven.
Come on out.
June 19th.
Yeah.
You're McConnell Williams and David Grove is your attorney. Have you met him before?
I mean, I just don't lie.
Yes, sir. I believe we met once before.
He doesn't remember you.
I believe, Judge, in fact, we got ready for a plea in this case.
You don't remember?
Not plea.
This is my first court.
I'm talking about meeting with him though outside of court.
No.
Well, we gotta.
I'll
So go on here.
I could for about 5 minutes, just. I don't have a telephone number.
It's an initial appearance at Stace, but you had been here April 9th and it was reset until today. So maybe something on April 9th and it says Mr. Grove is the attorney.
April 9th, I wasn't here. I haven't had a court. This was my first court appearance. I never ever received paper.
This may have been reset before the law.
It says, the resetting says, I said due to weather situation. So I believe that probably may have been what happened, Judge. It was for the hearings, trials too.
Oh, yeah, no. We could have done those today.
So it shows Mr. Grove was on your case as of February.
I didn't sign it.
Then,
Okay.
oh, here's what happened. Then there was a bond forfeiture.
Yes, sir.
Okay, you didn't appear. So you have a $50,000 bond plus a GPS.
They had got it recalled.
They did?
Yeah, the bond I thought you took them. I never received my paperwork for it. It says for a bond. Yeah.
So what is your bond now? You
I
know,
made it.
25,000?
It was 25,000.
Okay. Say, where are you working?
Well, right now, right this point.
How did you pay $25,000 bond?
That was last year. I was working there. You know,
Where were you working at?
I was driving trucks for a company.
Okay, you say 4 weeks?
Yes, sir.
All right, we're done. Get a resetting 4 weeks. Please. Thank you.
Yes, sir. No.
Yvonne Gilbert,
Yes. Yes, sir.
2 cases.
Sign on that one, did it for me?
I need those.
Yes, sir. Right, here's this.
And I got Robinson, please. Something more Robinson.
You're Javon Gilbert.
Yes, sir.
2 cases, 24 CR 1398 and 1399. A state jail felony of attempting to take a weapon from a police officer. Lucky you weren't killed. And a second-degree felony of assault on a peace officer in 1399. So state jail felony carries with it up to 2 years in state jail. And the other case, second-degree felony, You can be sentenced up to 20 years in prison for that case. What are we doing today?
Judge, on this case, she's 19 years old. I did get discovery from Mr. Ham. She did get an officer swimming. I applied for the free trial diversion program. She was denied. But what I want to do today is just take one more shot at asking for reconsideration. And the reason being is she's 19 years old. And I know Mr. Ham is aware that I did apply for the free trial diversion and they did reject her. I mean, I got a rejection letter from. So where I am right now is just asking for reconsideration. That's
What
what I
is
am
it about
today.
19? She's an adult.
Mr. Knaut's not going to approve somebody with this type of offense, Judge.
Yes. Good.
So I'm just asking them to reconsider.
But she's an adult, like most people here, they're adults. Once you're adult, you're held accountable to being an adult and to knowing better. You're not a child. And you're held to responsibilities after an adult. That's what's normal. Because, okay, she's 19, so then 20, 21, 20, where's the cutoff? Where you're too old? Or you're too young? There isn't. That's why we set it at 18. 17, yeah. Most people have rights and privileges at 17. Anyway,
Well, Judge, I just want one more.
I understand.
And that's it. Just one announcement.
4 weeks.
That'll work.
You got it. Thanks. Okay. And I've got Adam Dixon, looks like that has been reset for
Yes.
medical reasons. Princeton Giles,
Cooper?
Tom Burbank,
And Robinson is 16.
huh?
I said Robinson.
How did it,
please?
That's a full, that's 16.
Hey, Ben.
You keep saying Robinson.
Sorry.
I don't have.
They've been doing it.
You're talking about Derek?
Yes, that's
Come on up. Derek
I
Robinson.
don't have the plea paperwork. I just want to say it's to me.
I'm sitting there right now.
He said he sent it to you. It's all filled out.
30830 is now called the state of Texas versus Derek Robinson. That's you.
He's the case that he had for 7 years. So we're gonna move it today.
You're here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment in 18-30830 alleges that on or about April 20th, 2018 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance. Do you understand what you're charged with here? It was synthetic marijuana. If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, the fine may be assessed not to exceed $10,000. Do you understand? Yes. We're going to fake out the pad and use a different stylus. An agreement's been reached where you would be sentenced to
I put 7 months.
7 months. Is that right?
That's correct, Your Honor.
It's not my case, Judge. I was just standing here. for
You're
Mr.
just standing here.
Yes, sir.
Yes, sir.
7 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of the state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty? Voluntarily and because you're guilty.
Yes, sir.
Okay. Good luck. Here. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence?
No objection.
Without objection, it's submitted. Among other things, the state you're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement if nothing further. And find you, Mr. Robinson, you are pleading to the state jail felony of illegal possession of a controlled substance voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement, and you were hereby sentenced to confinement in the state jail for a term of 7 months. You will be given credit for all time you have served. You understand what has happened today, sir?
Yes, sir.
All right. We begin sentence immediately. How much time do you have credit, do you know?
You should have time served, Your Honor. I believe it's showing 211 days.
If you got enough time, they're going to check you in and then you go out.
It's gonna take a couple of business days. We do have to send paperwork.
Well, no, this is actually, I made sure it was at the jail here. The time he said in there on the jail here.
We still, because he sent us to state jail, we still have to send a teletype to state jail. So it
Okay,
may
right.
take a couple of business days.
Okay.
It may not. I can't. I'll do my paperwork today, but it depends on other entities, how long it takes for them to do their paperwork. So.
But they'll be able to see at the jail.
Very quick. I mean, you're taken into custody. That's just the way it is.
Yeah.
Okay. What else?
That's it.
DeMarcus Roll? Come on in. Did you get a resetting already? Did you get a resetting?
No, she's not.
Okay, he needs to get a resetting. He's clear to go. Thank you. Also, Patrick Plazan, come on out.
Have I highlighted that for you?
You're clear to go as well. Thank you. Zane Buren. On the other hand, you're not. You got drugs in your system. You got, you tested positive for tetrahydrocannabinol marijuana. Your bond is revoked. What is his bond?
1,000, Judge.
Is revoked. It is now doubled to $30,000. Yeah, you can blame yourself, not anybody else. You gotta have I'm gonna speak and you be quiet. Thank you. This isn't a debate. The test shows you've got drugs in your system. All right, and stand by. Yeah. You shouldn't be surprised. I mean, you're in organized criminal activity of making drugs. Anyway, your bond is now $30,000. Plus you have to have a drug patch as a condition of bonds. So if you post a bond, once any drug gets into your system, I'll know about it. And then you won't have a time the next time, but this one out. Mr. Dusler, you're his attorney? Yes. All right. He's going to be taken into custody. What's the next event?
An announcement, Judge.
An announcement in 4 weeks. That is all. And Mr. Buren on this date has filled out an indigent form. And Mr. Dusler will continue to represent him. On Derek Robinson, he is declared indigent and an attorney will continue to represent him, even though this wasn't filled out till he did.
Yeah.
months later,
Okay.
and the court is
Yeah.
just is accepting responsibility, not the previous
Okay.
JP that did not even have this filled out. That's
And this other guy.
Happy to be in my, unless he doesn't get out of jail.
Was that 1900?
If he's still in jail, though, we'll move him to a different jail.
those are. Princeton Giles, are you here? Princeton Giles? What about Quintavian Johnson? That you? Come on up, sir. You have those. Here's-
Do you want like a whole stack or
I just need Princeton Giles and Quintavian Johnson.
Giles and Johnson?
I need all of Burbank's because he's not here and I'm gonna have to reset everything. On Prince, your Quintavian, your attorney is not here and this was set for an announcement. I'll reset it in 4 weeks. Sorry that you had to. Have you talked to your attorney at all lately? No,
It's not since the last time he had.
it's Mr. Burbank.
He was on the murder trial.
He's next door.
Yeah, well, he's not here. I'm resetting it. Quintavian, that's Quintavian. On Princeton Giles. Where's Mr. Giles? Is that you, sir? That's not you? Quintavian, Princeton Giles. Princeton Giles, 24 CR 1157. There is no answer in the courtroom. I asked the bailiff to call into the hall for Princeton Andrew Giles. Princeton Andrew Giles. What is his bond, please?
Judge, just 1 second. Got a report done for the bailiffs.
House, we lost power.
Who's?
John West, he should be here in a minute.
There's no response to that name being called here in the courtroom on Princeton Andrew Giles. No response to the name called into the hall. Defendant has failed to appear. A warrant will be issued for his arrest. How much is his bond?
$8,000.
$8,000. His bond is doubled we're gonna make it a round number of $15,000. Plus he has to have a GPS device as a condition of his bond. Jamal McCain
Is it custody, Judge?
in 23 CR 1124. There is no answer.
Custody, Judge? Judge McCain is in custody.
This one's a motion to withdraw. Mr. Burbank.
Say that again.
I believe Mr. Burbank can file a motion to withdraw.
All right, well, it's passed. He's not here. We'll reset the case. Santos Navarez. That's you, sir? Come on now. This was set for an announcement. I'm sorry that you came up here. Your attorney is not here. Supposed to be here at 9:30. We're gonna have to reset this to another date in 2 weeks. Please get a reset. Thank you. Melissa Bell, Giles Cole. Yeah, you certainly are. Melissa Bell.
I don't know how I did that for me.
She comes.
Yep.
It's an announcement. What are we gonna do today?
Yeah, there's some things in the house. I see things that are simply there, just discuss.
What do you want to do today? For how long?
Sure.
How long? All right, 4 weeks. We'll be ready to go then?
Yes, Your Honor. I think the other case, there's another case along with this. I think that'll help to get this resolved. We're trying to get that one resolved, and I think that'll help this case resolved.
Okay, that's not on the docket though, the other one. Right?
Yes, Your Honor, it is. It's actually after this one, but we're working on the next one.
Oh, it's not Melissa Bell,
No, Your Honor.
Jameisha Butler?
Yes, Your Honor, it's a co-defendant case, but I think I'm also working on that. Mr. Constant,
Are you representing?
that's Mr. Darian Constant, her attorney. He's over there. We found that.
Yes.
Okay, so 4 weeks for you
Yes, Your
on
Honor.
announcement. Help us get a reset. Thanks, John. Get a reset right here. And that lady, thank you. Jameisha Butler?
I'm right there on calling it X.
Butler. Two cases?
Yes, sir.
Hold on.
Right, 25 CR 32 and 25 CR 33 are both called the state of Texas versus Jameisha Vicaria Butler. That's you? That's you? And you were here, your attorney, who is Mr. Constant.
That's great, Bill.
And you were in 32, you're charged with a third degree felony of evading arrest or detention. It says serious bodily injury. So that is a third degree felony, which carries with it up to 10 years in prison if you go to. Then the other 25 CR 33 is the first degree felony of escape. First degree felony, which carries with it up to life in prison if convicted. So this is an announcement. What do we do today?
Your Honor, just released two. There's a lot of
Discovering?
medical records and just released that to Mr. Constant. So he's got to review those.
I would ask 6-week announcement.
You got it. Okay.
Right,
Thank you. Thank you. Get a resetting. Thank you. Waylon Levens, reset the Lester Brister, please. The Lester Brister is called. Yeah, that file, any chance?
Highlighted X.
24 CR 1081, no answer in the courtroom. I asked the bailiff to call into the hall for the Lester Brister, please. You know what? He may be in jail. Is the Lester Brister in jail? He's in custody. Okay. His attorney, this is an announcement. Mr. Doyle, Peter Doyle. It's reset 4 weeks for his failure to appear. I'm talking about the attorney. It's not appear. That's hurts the client. Christopher Clinton, 19-32815. Your attorney is Ryan Gertz? Yes, sir. Where's he?
He was just in here,
He was
Judge.
just here, not here. Sorry, have a seat.
Over there.
Sorry. Is Luke Cooper, please? That's you? Your attorney is Ryan Gertz? Yeah, he's missing now. We're gonna have to find him. They're slippery. You gotta, like a fish in the boat, they'll jump into the water.
See, his cat was coughing, Judge. He's not.
Jessica Stewart. Yeah, but he's not here. Jessica Stewart, that's you. Same thing. Your attorney's not here. Donna Arnold. Donna Arnold is called. That's David Grove. I don't see Mr. Grove either.
He's here too. There's his cane.
If you can point him out in the room, does he need the cane?
I'm sorry,
He's not here.
Would assume he did, but. Like,
Have you talked to your attorney lately? It's David Grove. Okay, he was here. He's not here. He's must be talking to another defendant. We'll stand by. All right, just have a seat. Dior Frazier. Where's Dior Frazier? That's you. Yeah, you gotta wait until Mr. Grove comes back. Arnie Koenig. That's Arnie Koenig. That was reset. John Watkins. I think Miss Minaldi is the attorney on this one, and she's here. John David Simeon Watkins. There's, you can't make this up. The attorney's here, client's not here. Clients are here, the attorney's not here. John David Simeon Watkins, there is no answer in the courtroom. I ask the bailiff to call into the hall for John Simeon Watkins, please. Thank you. Have you talked to him today?
My office has a lot of communication with the district.
Today? What's his bond?
30,000.
Who's out there? No answer according to the bailiff's call. No answer to that name being called here in the courtroom. No answer to the name being called into the hall. Defendant has failed to appear today. And a warrant will be issued for his arrest. Bond was $30,000. It is now doubled to $60,000. The defendant must have a GPS device on him, so we know where he is when he's not in court, when he's supposed to be. Next, 18-28851, Kim Wynn. And Mr. Wynn Thomas is the attorney on that.
What's here? Just got that use the restroom for a second, Judge.
Okay,
And then I'll need the client to come fingerprint in front of me. Goes back to the courtroom.
okay, while we're waiting, Mariah Gallo. Mariah Gallo is called.
I'm sorry, I was probably doing it for things like when I said it. Just.
Say that again?
He's here, but he just told me to call his name.
But yeah, I will.
Was there a bar meeting going on? A bar association meeting in the restroom going on? That's.
It might be him, sir. Can wait. Come on.
Who is it? Kim? When's Kim?
And all different.
I'm looking for Mariah Gallo.
I'm getting to sign up.
Okay. And your attorney is Eric Smith? And he's the one in the restroom?
Yes.
Okay. Rigoberto Lara has been reset. Orlean Neely, are you here?
Yes.
John West is the attorney. Is he?
He's running late, Judge.
He's running late.
Place right there.
John West is your attorney?
Yes.
He's running late. I think he had no power,
Right.
This
Yes, sir.
morning
He didn't
and-
call in.
but he'll be here shortly. You, okay, just have a seat, sir. You are,
Mariah Gallo,
okay, your attorney, your client is Sue.
Call right when I did, Judge.
Yeah, Eric, you're Eric Smith.
I am, Judge.
Okay, Mariah, come on up. We need
Where's that?
Mariah Gallo. In 24 CR 1607, you were charged with second degree felony assault on a peace officer, which carries with it up to 20 years in prison. Very serious case. Mr. Smith is your attorney. And what are we going to do today?
So, Judge, I spoke with Mr. Sonny. He said he needed
Mr. Sonny,
to evaluate the case, Judge.
that guy?
That's not what you normally call me.
Is it not Sonny?
It's his first name. That's
Gotcha.
his first name. He doesn't want to give his second name. I think he's living an anonymous life.
Mr. Active, how about that?
Judge, I did tell them
That's
that I
what we're
would,
gonna call him.
All right, sounds good, Judge. I appreciate
What
it.
do you want to do today?
Mr. Active was going to.
told them that I would look at it.
Reset the case,
How much time do you need?
30 days, Judge, however long it takes, Mr.
About 4 weeks.
That sounds good, Judge.
All right, get it reset.
Absolutely. Thank you, Your Honor.
Yes, sir. You out of Houston?
I am, Judge.
How was the weather?
Well, I stayed in the Residence Inn last night, woke up, there was no power. So, took a cold shower in the dark. It was nice.
Oh. I wonder if that's my fault. I was chewing on a wire last night at the house.
To be honest,
Next thing
Judge,
I know, everything got dark.
I slept right through the storm. I didn't even
No,
know.
I had to come back from Austin yesterday and it was right behind us.
Oh, really?
And it was a bad storm.
It was black in the rearview mirror, clear in front of you.
Wide and it was moving fast eastbound. Yeah.
Interesting.
But it cleared out of it.
You know what? My alarm went off.
Everything's cleaner.
I got here on time. I appreciate it, Judge.
Yes,
Have a
sir.
great
Thank
day.
you. You too. Yes, sir.
Email me.
Okay.
Ron West is the other stuff.
I'm sorry, what was that? Yeah.
I'm not sure who's still left, Tom, on yours, because I'm.
Yes, it was. Thank you very much.
You're welcome.
Right, have a great day.
I sent them off. I mean, we don't know when, where, or anything. Is Jemiah McCain here?
He's in custody, Judge. We
No,
may,
he's in custody.
That's the one I want to,
Okay. What about Santos Navarez?
I think they're all left.
yeah.
Left. Melissa? Okay,
But it's Mr. McCain that we need to address.
all right.
Judge, he may still be in the back. I doubt they picked him up that quickly. If you want to go ahead and address it.
Well, I'll be known.
Yeah. We're gonna get to him here next.
Thank you.
Unbeknownst to me, I was appointed to represent him on a murder. And
In out of these,
out of these, in their murder.
yeah, 23 CR 1124.
Prior to that, I was appointed to a co-defendant, and I didn't realize I was.
Who was a co-defendant? Do you remember?
Marshall,
As a Marshall,
JW Marshall.
JW.
What happened in that case?
What's still pending?
Oh,
But I did not talk to Mr. McCain. I had no. I mean,
okay.
and so he just needs to be appointed an attorney. To represent.
Yeah, but he's got 3 cases, so we're gonna have to, all 3 of them, I guess, huh?
I would that.
All right, so what you're saying is you got a conflict
I do.
here on the murder case 23 CR 1124, which is going to be, looks like the most serious of these 3 different charges. The others are 3rd-degree felonies. And these will all be carried together. So anything state you say?
No, Your Honor.
I'm good cause then to release Mr. Burbank. Were you appointed on?
I was appointed on Mr. McCain, but I was previously said.
Well, what are y'all asking? This in the capital murder case, is it?
No, Your Honor.
Okay, then we're gonna appoint whoever's next on the appointment is
Okay.
on the indigent. I presume the defendant was indigent.
He's still in custody.
Sir,
He's in custody.
no, but is he indigent as far as you know? Yes. Mr. Burbank said,
That changes
all right, then
the status of it.
we'll reset it for 4 weeks and the attorney needs to, whoever is the new appointed attorney needs to be made aware. Yes. Kim Wynn, thank you. You went one.
Oh.
I need Mr. Wynn, Mr. Wynn.
You should let it go.
And we now call 18-28851.
Hey, Tom.
Kim Wynn, that's you, sir? And Thomas Wynn is your attorney. Are you related to Mr. Wynn? Wynn is like a Smith, isn't it? The language. All right.
Giles, Mr. Giles. What you had was a-
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, we can, Your Honor.
In summary, Mr. Wynn, in 18-28851, you were charged with the state jail felony of engaging in organized criminal activity. And the indictment goes on to state that on or about January 4th, 2018, my God, I was just a teenager back then. Why did this take so long? Did you move or something?
Yeah.
Joe, are you still living at 11814 Sharpview?
Yes.
Okay, in Houston? Something must have happened, because that's, we're talking 7 years.
It's a long time ago.
Long time ago. It looks like you were at 17814 Sharpview at one time. Then it's 11814 Sharpview is where we have you now.
I never been at the R1 meeting.
You never been at 17814 Sharpview?
No.
Never lived there? That's what happened. That's what the indictment shows. But you're at 11814
Yes.
now. Okay.
Somebody transpose a number from 7.
Yeah, one number off.
Yes, sir.
Which in Houston, that's everything.
Yes.
3 million people. All right. Again, on or about January 4th, 2018 in Jefferson County, Texas, you committed the state jail felony of engaging in organized criminal activity by intentionally and knowingly operating and participating in the earnings of a gambling place. And which involves eight-liner matters.
Yes, sir. We're pleading to the lesser included of gambling promotion, which is on that second paragraph on the next page. Part of the offense offense of
Well,
gambling.
this is, I've never seen an indictment written like this with what appears to be three different paragraphs. So each of these paragraphs constitute a separate offense?
No, sir. They're all one offense is the
Second and third?
Yes, sir.
Second or third?
Yes, sir.
Either one is good, right? It doesn't require second and third.
Well, no, they both say and, so that it's part of it's not or, it's an and, so it's all one crime. It's just the way they alleged it. But we're proceeding under the lesser included of gambling promotion, which is the last part of that last paragraph. Make it a class A misdemeanor.
Yes. Yeah, he does.
Gambling's in 47. It's 4702 is gambling, so we can 47.
First disposition of gambling paraphernalia thing.
Good luck with that.
It's in Code of Criminal Procedure. All right.
Yes, sir. And I think court through the word have been filed on all of these, so I think that's already been taken care of. This is dealing with he's was one of the employees that was working there. It was not a manager or anything.
So section 71.02 Texas Penal Code,
Yes,
among other things, states that person commits an offense with intent to establish and maintain or participate in a combination or in profits of a combination or as a member of a criminal street gang or foreign terrorist organization, which is inapplicable here. The person commits or conspires to commit one or more of the following. And subpart 2, any gambling offense punishable as a class A misdemeanor.
Yes, sir.
So you go to gambling under chapter 47.02, a person commits an offensive
We're doing
make the
gambling
bet,
promotion.
make the bet, plays and bets. And that is no, that is a class C misdemeanor. What we're looking for is what it takes for a class A misdemeanor.
Gambling promotion is the one with.
47.03.
Yes, sir.
That is a class A misdemeanor, operates, participates in the earnings of a gambling place, engages in bookkeeping, bookmaking. For game, becomes a custodian, sells chances. Or. For games, sets up, remote. Okay.
Yes, sir.
So all of those are different ways. You can commit.
Yes, sir. The last paragraph, last sentence talks about committing the offense of gambling promotion or keeping a gambling place. So we're going gambling promotion because he did participate in the proceeds.
Okay, that is all under 47.02. That's what he's going to be, the lesser included offense.
Yes, sir.
Is what he's gonna
Gambling
be.
promotion, yes, sir. 4703.
So we're taking organized criminal activity out and then
4703. Gambling
section
promotion.
47.03, a person commits an offense if he intentionally or knowingly operates or participates in the earnings of a gambling pay.
Yes, sir.
place.
Yes, sir.
And this states
The last paragraph,
that
it states
then
that
and there,
if you look at the last paragraph on the last page, that top part, it says participated in the proceeds of.
right here in the first paragraph, it says, did then and there intentionally and knowingly operate and participate in the earnings of a gambling
Yes.
place.
Okay.
So it appears that it is clearly a lesser offense that can be applied, which is a class A misdemeanor,
Class A.
carries with it up to 1 year in the county jail and a fine up to $4,000 and or a fine up to $4,000. Do you understand what you were charged with here in this case, a state jail felony, but what is agreed upon between the lawyers that you would be pleading to the lesser included class A misdemeanor? This pad, we won't ever use it again. This,
Very touchy.
it doesn't show up until about 3 seconds after you write. And then, so you can't
We only do it for 10 seconds.
write
It's right
much.
after I wrote it. Nothing bad was enough.
God bless you. An agreement's been reached where you would stand by.
Michael.
Class A, you would be pleading guilty to the class A misdemeanor gambling promotion. And be placed on 1 year deferred or unadjudicated probation. Is that 500?
Yes, sir.
Fine. Okay, I got it. That it turned out to a 3. Not 3, it's 5.
It's 500.
Redo it, 5. And placed on 1 year deferred or unadjudicated probation for this class A misdemeanor, $500 fine. There would be other terms and conditions of probation which are normal and customary for this type of crime. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included class A misdemeanor under the state jail felony? Guilty or not guilty?
Mute.
Are you pleading guilty voluntarily and because you are guilty?
Mute.
Yes.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Did you understand it? Discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence and without objection.
No objection now.
Admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses like you were pleading guilty to now. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I'm going to follow this agreement and find, sir, you are pleading guilty today voluntarily to this Class A misdemeanor of gambling promotion. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to do that. I'm going to defer any finding of guilt for 1 year, place you on deferred or unadjudicated probation. You must follow certain terms and conditions of probation. There will be a fine of $500, which must be paid. And the probation officer will go over those terms. If you do well within 1 year, this case will be dismissed. Do you understand?
Yes, Your Honor.
If you fail, your probation could be revoked and you could be sentenced up to 1 year in the county jail. We don't want that. So please see the probation officer and do well. Thank you. Yes, sir. Thank you. David,
Yes, sir.
who do you have that we need to deal with? I've got Donna Arnold.
I have
And-
Arnold and I have.
Dior Frazier.
So, I don't know.
And Donna Arnold, can you give me those two files? Donna Arnold. Two cases are called 24 CR 1879 and 1880. The state of Texas versus Donna Arnold. There is no answer. Is that you?
Yes, sir.
There she is.
All right, Judge, I'd like to have about 4 weeks for Miss Arnold's case, so we can discuss it this.
Resetting, please. Thank you. Right here, 4 weeks. Next is Dior Frazier.
Dior Frazier is on back, Judge.
Come on up.
2 weeks ago, Judge, I told the court that I would have her case finished, and I would have to tell the court that I don't. I received a new person to talk to, if I could have another couple of weeks.
You got 2 more weeks. Great. Thank you. Get a resetting, ma'am. 2 more weeks.
Sign it? Yes. The story is two cases.
I think that's it for you.
Yes, sir.
Um,
I've got one that was reset in my name that I did not have on my docket. her name was Deanna Preston, but it shows that I represent her.
Yeah.
I'm sure I do. I just
Yeah,
was not up there
right.
when the court called her name. Yes,
Yeah, it must have been reset.
yes, sir.
Because I've got a line
reset
to-
for about 4 weeks.
Judge Giles that we called earlier is now arriving.
All right. On, is it Zane Buring or DeMarcus Roy here?
You get the bump for marijuana, you.
DeMarcus Roy.
Okay, but what did I do with DeMarcus?
You reset him already. That's the name.
Okay, yeah, but-
Need to file.
yeah, Christopher Clinton in 19-32815. I'm gonna need Cooper and Stewart as well. What are we here for?
Do you have one?
It says other here.
It's a judge, or I guess others did other different. So we're waiting on a case involving a determination of whether he is lawfully required to register as a sex offender out of the Austin District Court that we filed. And we've got cross motions for summary judgment going on in that case.
What do you want to do today?
And then we just need to reset it.
How much time?
We need 8 weeks at least.
All right.
It's 2,000 days old, just so you're aware.
Well,
When I reset.
Well, I know,
want you to
but
get that.
we're,
Okay.
Sorry, we're following the process that the legislatures make us follow. Instead of letting him determine whether or not it's a lawful determination, they require a district court in Austin. So it's not.
Yeah.
Nothing we can.
it's gonna be 8 weeks, but if we find out sooner, let us know, or if we don't find out, let us know so we can get this moved.
We understand. Thank you, Judge.
Cooper. Luke Cooper,
He's coming up, Judge.
that's an announcement, and then Jessica Stewart.
Judge, on Mr. Cooper asking for 4 weeks, resetting. We've got discovery relatively recently, and I need to sit down with Mr. Cooper and go through it.
Is that gonna be enough? 4 weeks? All right, get a resetting. 4 weeks, please. Jessica Stewart. Oh, I just,
I got it. Got it. Great.
Jessica Stewart.
I agree with you about the restitution.
And 23-2119, Jessica Chanel Stewart, that's you?
Yes, ma'am.
Okay, this was set today for an announcement. What are we announcing?
Can we hold on this one just for 5 minutes, Judge? I think we might have a resolution.
Okay.
Thank you, Judge.
Orlean Neely. John,
It's not.
Orlean Neely, I'm gonna need some of John's cases, please, beginning with Neely. What are we gonna do here?
Your Honor, we're still negotiating them. We have an offer, but we're not, we're
0,
not there. Yeah, I know. So if we get one more resetting, we
3
we're
weeks.
close. Oh, 3 weeks, that's fine. Reset.
Kong, Ham,
He's outside. We're about to do his paperwork. That's what I was doing outside. Your Honor.
he's what?
We're about to do his paperwork. He's gonna plead.
Dion Showmate,
Your Honor, Mr. Schumate should be here.
24 CR 901 is called. Dion Showmate, no answer in the courtroom. I ask the bailiff to call into the hall, please, for Dion Showmate.
Your Honor, this is the one we're waiting for a response on Veterans Court. I think it's our first one request that come here, so. I said, if he's here, no novel.
No response, Your Honor.
There's no response to the name being called in the courtroom. No response to that name being called into the hall. Defendant has failed to appear. There was a last setting on April 1st. Several settings, but anyway, defendant has failed to appear. What is his bond, please? Beyond Showmate.
Thank you, dude.
Beyond Showmate, 24 CR 901.
That one, she's 710, John was hired.
Okay, I already reset it.
Yeah, you were hired in on that.
Yeah.
So when you did the letter, sorry, confusing.
That's why it's not here then.
Paul Smith.
Your Honor, this is one we're trying to get in touch with the third witness or third party witness to make a resolve, so we can get about 3 weeks in this.
3 weeks on Paul Smith, Michael. Stelly.
Yeah, come around here. Mr. Stelly called this morning in my office and said he had a doctor's appointment with a doctor. I told him to get a note from the doctor and we provided to the court. So the court wants to revoke his bond. And then if I get that doctor's note.
24 CR 1782 is called the State of Texas versus Michael Stelly. There is no answer in the courtroom. I ask the bailiff to call into the hall for Michael Stelly, please. Thank you.
No, I should have the doctor's note. Not these 4 days now.
There's no response to that name being called in the courtroom. No response to the name called into the hall. Defendant has failed to appear. Warrant will be issued for his arrest. What is his bond, please? 24 CR 1782, Michael Stelly.
$7,500.
All right, it's doubled to $15,000 plus the defendant must have a GPS device. And that's going to get processed through. You got to get me something from the doctor.
So say if I get something from the doctor, that could be.
Yeah, but I mean, it has to be.
Oh, I know. I'll get
It's
something.
not like.
Oh, I know. I understand. We told him that.
I didn't know.
As soon as he leaves the doctor's office, he gets sent
James,
to us.
James Wilson.
Wilson is right there.
Come on up, Mr. Wilson. James Anthony Wilson is called 24 CR 52. You're charged with third-degree felony of also engaging in organized criminal activity, namely burglaries, thefts, and credit card abuse, a little of everything. Don't ever show up in this courtroom with that shirt or anything like that. Just look around. Just look around. There's a tie. There's a tie. There's a man with a shirt, but just that's not appropriate. Would you wear that to church? Why not? Because it's disrespectful. So you don't think much of court. This is about the Constitution of the United States, what we do in here, which is something to be honored and respected. You got to act like it. I can guarantee you wear that in front of a jury would find it offensive and wouldn't give you the time of day. You got to do better if you can. What are you asking for?
Some time around this is, there's some issues regarding the underlying politics here, so we got about 3 weeks to be great.
3 weeks.
Resetting and I'm like outside.
Resetting.
I think that is all to have this morning.
Did you do the thing?
I'm clean that one.
Oh, okay. Okay.
Are you ready on?
No, I got to pick one down.
On
What do I have left?
Jessica Stewart, you already called it. I asked you to hold. We got it worked out. I am going to dismiss for restitution and
Okay, where's Jessica Stewart?
I think he already sent her to the bank.
Come on up.
Oh, she's still here.
23 CR 2119. Who is your attorney?
Yes.
Mr. Gertz. Apparently, this is going to get dismissed if something gets done. How long is that going to take?
Yeah, I think.
Oh, today?
I thought he already said.
Oh, okay.
So-
Gets done today. It gets dismissed. Today.
I'll take care of it this afternoon.
What we'll do is, we'll hold it until the end of the day. If nothing's done, then it'll be, reset, for like 1 week or something. But get this done so you can move on with your life.
Yes.
All right. Thank you. We'll hold it in suspense until the end of the day and then reset for a week if it doesn't, if you don't get paid. If you don't pay. Yeah. Yours is what?
She's called, it was a, I don't think
Where was it?
he was whether we landed judge, he was without power, his phone's dead, as soon as he found out, from him, he got him, then.
Okay. 24 CR 1157, Princeton, Andrew Giles. You are charged with the 3rd-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. So that's serious. So what are we going to do?
I just need a couple of weeks to get into a point.
2?
Yeah, well, give me 3, because 2 gets me into a trial.
You said a couple. I just couple. That's 2, but a couple of 3. A couple of 3.
Couple of 3.
You got it. Reset 3 weeks. Okay, get a resetting.
Thank you, Your Honor.
I'll get it. Got Hong Pam with John West. Anything else? We're waiting on John to finish papers. Okay.
Your Honor, if I could address that for you first, I just do something.
I don't know, who are you?
I'm the father of one of the defendants who got, I think, already locked up, Jane Geary.
Okay, who is his attorney?
He has a point of attorney, but I was not, actually, that's what I was gonna speak to. I was gonna try. He got his bond revoked by you, so you know, had it earlier, year, that was his, sir.
Oh, today?
Yes, sir.
Okay.
And, well, sir, he was only arrested March 16th. And he, in school, he's working, he has not been using, he hasn't had enough time for the THC to get out of the system. And his attorney was just a point of, he could have told you that. But it was, sir, he wasn't even picked up, he didn't even have a clue he had a warrant. But he has not been using, sir. I'm his father, I'm it's watching every single step of the way, it's making sure he's reporting, making sure he's doing what he's supposed to do. He's enrolled in school and he has a job at a recording studio. He is.
Yeah, that's right. I remember hearing about that.
Yes, sir. He is all the way out of trouble, Your Honor. He has not been using.
The scientific test proves otherwise.
Well, but.
It's not a debate.
To arrest.
I'm sorry, it's not a debate. If he has drugs in his system when he's tested, that's all we know for sure, because you don't have any method of telling when that went to, you're gonna speak over me? You don't have any method of telling when that might happen. You don't know. You don't know. But when they're tested in the courtroom, when they test positive, sorry, they shouldn't have been ever using drugs in the first place. But when it tests positive, there is no way you can say that that didn't have anything to do with recent use, misuse, not you. So you can, all right, you need to tell your attorney, the court's orders are what they are. I'm not changing them because of your opinion. Who is the attorney on the case? Who? Don Dusler. Is he around?
I didn't understand why he didn't say that to you in the beginning when you reported. He didn't argue anything and I didn't understand that.
You need to call him and talk to him. Don, what's his phone number?
Walk down on me, sir. I tried to speak.
I'm gonna give you his phone. I'm gonna give you his phone number. Here, come on out. Yeah, you have a right to talk to him and to get heard and find out what his plan is on representing your family. Yeah.
Your Honor, I tried to speak with him and he told me he didn't care and that I get to go
do something. We tried to speak to him 3 weeks since he was appointed to him. He would not answer his phone. He would not return calls. He would not return messages.
All right.
Not from
What's
anyone,
what's
sir.
the defendant's name? Again, your son's name?
Zane Buring.
Okay, I'm gonna set that for a hearing tomorrow morning. And
Know if I can.
Okay, we live in Austin, Texas. I
Yeah.
got
I'm
up at
sorry.
4 a.m. to be here.
yeah,
We were gonna
see, he's gone. What I wanted to do is set it for tomorrow, have Mr. Dusler in here explain why he's acting that way. If that's the way he's acting now, I'm hearing your version. I want to hear him too.
Yes,
But he's supposed to handle, all the defendants are supposed to be represented by competent, vigorous
and
representation.
he told me outside he didn't care, sir. And that's where his words.
Well, I'd like to, yeah, I need to,
Is there
to talk to him
was
about
standing there when I was trying to talk to him?
I didn't hear anything.
Oh, he would, he told me he didn't hear.
Yeah.
He was saying he was outside.
well, I mean, don't call witnesses if you
Sorry,
don't know what
no,
they're
sir,
saying.
I'm sorry. I just thought, no, he was standing there. I apologize. But Your Honor, I can attest to my son has been staying out of trouble.
Okay, but
I-
the scientific test proves otherwise. We've been doing this 19 years, sir. and
It's been less than 40 days, sir, since he was arrested. And I promise you, sir, he's been doing everything to stay out of the way. Enrolled in school, in college.
You're saying that the marijuana has been in his system for 40 days?
Sir, he's.
Is that what you're saying?
Yes, sir. I would like
Sorry,
I would-
it's not gonna work. That it doesn't, that's not
Marijuana
the way
can
it
last up
works.
to hair follicles 90 days, up to 60 days in your urine if you're a chronic user.
Anything else?
No, sir.
Okay. We're gonna give you, Mr. Dusler's number. I want to know if he's recusing. There's a posted note right there. If he is not, if he does not, answer phone calls in regards to immediate family members who are trying to
Yes.
get information for their client, that would be inappropriate. And I'll have,
Yes, sir. I'm sorry.
and then, he's appointed at the court's discretion. And if lawyers are not, treating clients and relatives, of clients, especially those who are in custody appropriately and professionally, then I'll deal with it firmly.
Your Honor.
And that, I don't put up with that, and I don't generally get complaints. But when it does, when we do, we get to we address them. You have a right to find out as much information as you can about your child.
Your Honor, but Your Honor, I promise you, my son, I wouldn't be standing here if it wasn't for the fact that he was moving so well in life. I would not be standing here, Bridget. Okay, and
Well, look, just at the end of the day, not to say that you're don't act naive, but let me just tell you, when people use drugs, I've only been doing this for 40 years, involved as a defense attorney,
Yeah.
a prosecutor, a judge now for 19 years.
Yes, sir.
When it comes to drugs, people are rarely forthright
Yes, sir.
because it's something they know is wrong and they hide it, and it gets the best of them, and they lose their abilities to really think rationally because they become the drug overpowers them, and it's always been that way.
Always, yes, sir.
And
Long as
I see it over and over again.
brother
And
died of
the
drug
family members are the last, they're never going to do things in front of their family or let their family know because they know it's wrong. They're ashamed of it, but they're stuck. And I'm thinking, when we deal with this, we have a 92% success rate in our probation, especially drug cases.
Yes,
The average is 75% in the country.
yes.
We have a 92 because we deal with things pretty aggressively on getting help, especially with drugs.
Yes, sir.
But
Oh,
I know what you're saying.
He has.
But
he
I
doesn't
know,
use
I
any
don't,
Other drugs.
but I
at
know
all.
what happens over and over
Yes,
again
yes.
for 40 years, sir.
Yes, sir.
40 years.
I have no
It's-
doubt in my
The
mind.
parents come up here and they're shocked and ashamed and they're trying to defend their child, but he's a grown up.
Yes, sir.
And you don't see him all the time.
We.
And you don't see him all the time, and they're not gonna use drugs in front of you. They're
No,
not
sir,
gonna
I-
run
I do.
embarrassed.
Yes, sir. I wouldn't, I understand what you're saying. Yes, sir.
But
Again,
and
he
the
doesn't
scientific
use-
test is what we use, and that is
Your Honor, if
is,
you were
uh,
to give him a
proven.
chance, if you were to give him a chance, I can guarantee you, he comes back in for 30 days, he will not have anything in his
it's in the
system.
debate.
That would give
I don't
plenty
deal
of time
with,
for his system to be clean of
I
marijuana.
can't deal with, I'm not gonna deal with you on that. He tested positive, and that's what we test for. Now, his lawyer needs to get in the game to get him up here so we can resolve this case one way or the other.
So that's when I had asked him outside. I asked him if he would come in and try to talk to you. He says, no, this isn't Austin. And I said, sir, you're here to represent my son. He said,
That's,
do you live in Austin? He brought up Austin again. I said, sir, I lived here as a child. I know what.
I
you see."
understand, and he
And then
shouldn't,
he walked off on me. And I
Well-
said, sir, can you please go let them know he hasn't been out?
Are you-
long?"
but you're not gonna be able to be here tomorrow?
No, sir, I missed up. I own a tattoo studio and
Okay.
he's got school in the morning and work tomorrow.
I'm sorry. I can get him back in the morning and talk to the attorney and have him explain, but you're not gonna be here. And having explained what you have told me, and without you being here,
Yeah.
it's not gonna be much of a debate.
Yes, sir.
But I can bring your son back and ask or direct him, since I appointed him
That
as
would
the
be
attorney,
amazing, sir.
direct him to aggressively deal with this case and also be forthright with family members, close family members, so they are not in the dark on the way he's gonna represent your son.
Yes, sir. I can show you numerous calls that we've made to his office, both of us over the past 2 weeks. No answer, no reply to messages, very thorough messages, very clear. Made sure we just need to get some information about court. We were trying to appear by Zoom today because we live so far and he
Yes,
had
sir.
work.
Oh.
And we thought that would be better, but Your Honor, I
But
promise
see,
you.
that's,
if
see,
he
that's
wasn't
another problem.
working so hard
This
to
is why
stay
I
away
don't
from
do,
here,
see, this is also why we rarely do Zoom, is because when it's dealing with drug cases, we don't have the ability to test.
Sure,
And
yes, sir.
I can guarantee every drug defendant would want to appear by Zoom, and we're not able to test, which is what we have
And
to
Your
do.
Honor, we didn't get a reply. We drove our butts up here. I got up
Good.
at four o'clock this morning after I worked till midnight.
thought
I
the
slept
storm-
an
you got
hour.
Caught in a storm, huh?
I drove through it, Your Honor.
Yeah,
I
yeah, it was a
drove
bad
through it.
storm.
He's not a flight risk. He's not going anywhere and he's not a doper. He smokes in the hot, man. And I.
That's not right,
No,
but that's not
no,
right.
it's not.
And you
It's
don't
not
even,
right.
and here's the
he's
deal,
not-
you don't
he's
even know
not
what you're, if, unless you're making it, you don't know what's in it anymore.
Right. It's
I mean,
dangerous.
I had people here with synthetic marijuana
It's
cases.
so
which
bad.
is-
And you know,
which is
well,
like-
there's a lot
like-
of legislature going on, so there's a lot of that stuff, THC going on in Austin right now. And I totally understand it's illegal, period. But Your Honor, I promise you, it's been a small amount of time, and with the amount of weed that these guys smoke every day, all day, I know that he's doing the right thing, Your Honor. If he wasn't, I wouldn't be standing here. He's doing better than he's ever done. His mother's been in prison for murder since he was 4.
So
I wasn't worth. His mother's been in prison for murder since he was 4. Out of this, Jennifer Walter. Yeah, that's
in this court?
I don't know who it was Halloween night of 1999. Jennifer Walter and Christopher.
Okay. Yeah, when that's before I got there.
Yeah. It was me. I was 19 years old when I had him. It was me. And that was it. And I didn't have any parental guidance. I'm lucky to be standing here in front of myself, sir. I'm
Why is that? Because you've learned to make the right choices.
because I didn't make I didn't make good choices, and I didn't have anybody to help me make good choices, but he has somebody here now. And although I wasn't doing the best when I was younger, as past 14 years have been phenomenal. I own 2 businesses. I also help with an entertainment company, and I'm staying out the way. And I've worked, I would not, A year and a half ago, I would not be standing here talking to you. I wouldn't be here.
What I do when you test positive, you heard.
Yes, sir.
Bond is revoked,
Yes,
then
sir.
it's double. Plus you have to wear a drug patch.
Yeah,
And
and
that's
I can't
all of
afford
the-
double the bond. I
Well,
spent everything I had just to get him
What
out. and I
I'll
would
do is
only-
I'm gonna list, I'll bring it back tomorrow. Whatever the bond may be, I can change a bond.
Yes,
for
sir. I'm
anything.
poor.
But a drug patch is going to be required.
Yes,
Up-
Your Honor, if he comes back in here and he's dirty, lock him up and don't give him a bond. I don't care.
But
I
he
promise
can't,
you, he's
we
doing
don't
good.
release him until he tests negative.
Okay, yeah, I will.
And then he's gonna have to have a drug patch, because if you put a drug patch on early, it'll test positive.
Yeah, right, yeah, yes, sir.
When they
And
take
I don't
it off.
want that for him.
Yeah,
And I just don't want him to get kicked out of school.
So we'll bring him back tomorrow.
Yeah.
Then I'll do, I'll do a drug test on him and see what happens tomorrow.
Okay, yeah,
And then-
it's just for marijuana and that stuff binds to the
No.
fats. It's not like it's out of your system in 72 days. If you do the research, it binds to the fat cells in your
Thank
system,
you.
30 to 60
I'm
days.
familiar with
Yeah,
it, sir.
Up to 90 in
But,
the hair.
but too often marijuana is used
Yes,
as
sir.
a carrier with other methods. And
He just had,
also you don't know what's in the, how marijuana, some marijuana is stronger than others, and it just works that way and works differently. And that's why when you sniff it, if you smell it, you run like the wind,
Mhm.
especially if you're on bond. You don't even want to sniff it.
Yes,
You
sir.
want to move out of the way, stay out of the way.
Oh, and that's almost.
Because you don't
impossible
know
out
what it's
there.
gonna take to get into your system. And the tests are those are profoundly accurate tests. Is what has been proven accurate for decisions and science. So that's why we don't do it flippantly.
If it had been over 2 months, I would definitely not even have asked you anything about that or even attempted to. I just thought his attorney should have said, Your Honor, sir, he has only been out of jail for 40 days. He hasn't had enough time to get his system cleaned out. Give him a couple of weeks to get his system cleaned out, come back, take a test.
We'll bring him back tomorrow and
Yes,
see
sir.
where he is.
Yes,
And then I'll bring him back every few days until it tests negative.
Okay, and that's fair. And when he
That's what
tests
we-
negative, sir, I promise you,
And I'll talk to Mr. Dusler about what your complaints are, but
I'll try again, Your Honor,
Yes,
to
sir.
contact him. And even on his Google reviews, it says he does not contact us. Because I tried to make sure I was following the right thing. And on the reviews, it says he will not communicate with his client. And it's several reviews if you look yourself, and that's the thing.
yeah, I don't.
I was scared when I walked out there and he was representing my kid because he didn't even sit here and say, oh, no, sir, he's this,
Okay,
you know.
I
That was the
understand.
first thing he should have said, was that he has only been out for
Yes.
40 days.
okay. All right.
Well, I really appreciate
Thank you,
you
sir.
taking the time to
You
listen.
have
to
his,
me.
you have the defendant's name for tomorrow
Yeah.
on this case? Thanks.
I get back.
Do I have a plea? Thank you.
Done it twice and it's hung up on me, so
Hey, this is just terrible today.
Oh, I know.
Yeah.
Hi, there we go.
Yeah.
One of the things I looked at Giles, Prince Giles, did you withdraw the bond?
Yeah, we didn't do it.
Okay.
Yeah.
I didn't,
No, it's okay. At least he had a note that you would come.
Okay, John, we're waiting on your plea.
Yeah, as soon as I.
Good
get
luck,
it,
because this,
okay.
I don't know what the deal is with these, the power, when the power went off, something went out.
Power outage.
But we've had some pleas done already. Try it, keep trying, John.
Oh, it said that some would be that way. Hung up, it says, Jimmy.
So we're agreed, it's Jimmy Hampstall.
I'm not gonna blame anybody today.
I think it's like server. I think they had to reset. I think they had.
Thank you. Where is Mr. Pam?
Oh, we're just getting there.
Tom?
Right there.
Nose to tail yesterday, driving. Could get over 50 miles an hour for 240 miles
Where we going?
from Austin.
Oh, I'm dying.
Well, I stopped for and saw my daughter and and then my mother.
I-35 was insane.
Huh?
I'm coming from Dallas to Denver.
35?
Oh.
Well,
For a while, it was good.
Leaving Austin was just terrible. It was at noon, 11:30 to noon. We thought, well, we'll beat the crowd. No, it was, and then you get to the point where you got 290 or Interstate 10, where you go to Bastrop.
Yeah, you make a choice.
21 to Bastrop, or you stay on 71. And fortunately, everybody seemed to be going to 10. They stayed on 71 and we go to Bastrop. But then at 290 was just as bad. And coming up, when we came up on 290, there were two major accidents in the only major intersection of two small cities that we were going to, and we were packed back for miles, trying to clear out. And one of them was a big industrial, something was hauling a bulldozer and it fell off. And you don't pick that up.
No,
and put it on the low boy.
A little hard to.
That thing was a mess.
Yeah.
That was in Caldwell, I think, the city of Caldwell, a little town. Wow.
We were supposed to go camping this weekend and changed our mind and just stayed home. So, and then the in-laws wanted to keep the little one over the weekend. So I'm like, go for it.
Well, I got up there and the grass was about this high.
Oh.
I hadn't cut the grass this year up there, and it was out. So I cut the grass.
Yeah.
Sunday. And turned out, thank God. Well, first thing, I went to start the engine on the Husqvarna. I love that. The Husqvarna. Click, 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 click. Click, click, click. Had to go find a battery. And those, first time I changed the battery, and that, the way it's set, you have to have certain tools that I had to kind of.
Get the tools too.
I had.
Oh, you had the tools.
I had to use the tools I had.
Oh,
It
okay.
took a little longer.
Then the tools you should have.
Put that thing in.
Yeah. It's,
Yeah.
Yeah.
Thank God for Die Hard. Worked like a charm once you get it in.
Yeah.
You get a good battery. No, it reminds me, I got the battery. I dump a battery here in this town for recycling. Because you can't just throw it in the trash.
No.
You gotta put it in the recycling, and I'm not sure where.
What about to the landfill?
There's a lot of places.
The landfill has marked places. If you don't want to go there, you can contact a local
There are local people who have it.
auto parts store. Yes, sir.
Because I think they get a rebate or something for it when they bring it back, I think.
But you gotta buy one.
Yeah, they'll get the rebate, but they get this, yeah, they get
They'll take it from you because they get.
they get something out of it. From when they bring it to the place for disposition, and
Don't.
Yeah.
like I said, we had a nice relaxing weekend.
Perfect.
Little one went to the grandparents and they, my in-laws said, well, I know they go. Keep going up and just.
how deep is it?
It's size pond. I mean, it's fish. I mean, it's got plenty of fish.
Oh, wow.
And then my sister-in-law has got a new working on fish, and he cleaned up around the pond, repaired his deck and got it all in shape. So she went fishing this weekend several times.
All right, 24 CR 2109 is called the State of Texas versus Kong Van Pam. Mr. West is the attorney. Are you Kong Pam?
Yes.
Do you speak English, Mr. Pam? A little bit? A little bit. Ciao. And do you speak English and Vietnamese?
Yes, sir.
Fluently? Who are you?
I'm
You're his niece. What is your name, ma'am? And how long have you been speaking English and Vietnamese in your life? Your whole life?
Yes, my whole life.
Okay. Raise your right hand. First of all, that's your left hand. God bless you.
He doesn't have a right hand.
Oh, he doesn't have a right hand. What happened? What happened? Was it in an accident?
Yeah.
Sure about accident.
Oh, that's terrible. Okay, but raise your left hand and your right hand now. Do you solemnly swear or affirm that you will truly translate from Vietnamese to English, English to Vietnamese, Mr. Kong Pam's, and he's your father?
No, he's.
Your uncle, his answers that he makes from Vietnamese into English, and the questions that are asked of him by the court or by his attorney, English, you will translate into Vietnamese, the language that Mr. Palm understands. You will do that correctly and accurately, so help you God.
Yes, sir.
And I'm going to ask you to translate to Mr. Palm. I'm going to speak English, and I want you to speak Spanish. Spanish is what we often do.
Yeah.
Speak Vietnamese, translate Vietnamese. Are you Kong Palm?
Ông có là ông Công.
Yes. You can put your hand down.
He said yes.
Okay. Do you solemnly raise your right hand, your left hand? Do you
Gosh.
solemnly swear or affirm
Ông có hứa là nói sự thật.
that you will make true answers to such questions as may be asked of you during this hearing,
Và nói sự thật. Và hứa nói sự thật không?
and you will answer truthfully, so help you God?
Yes.
Lower your hand. And I'm going to ask him questions and just repeat, ma'am.
Yes, sir.
And tell us your full name for Tiffany Lee. Do we have that? How do you spell Lee?
L.E.
Okay. Are you Kong Van Pham?
He said yes.
Okay, you just, you won't say he said, just, you'll answer yes on his behalf, just like he speaks. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 10th, 2024, in Jefferson County, Texas, that you committed the offense of operating a motor vehicle while intoxicated. Do you understand what you're charged with?
Yes.
The indictment also goes on to state that you have 2 or more convictions of operating a motor vehicle in a public place while intoxicated. This states that you were convicted in 2005 and 2011.
Yes.
Do you understand? All right. If convicted of paragraphs 1 and 2 of the indictment, you are facing a 3rd-degree felony, which means you can be sentenced to no less than 2 years in prison, no less than 2 years in prison, up to 10 years in prison, and fine up to $10,000. Do you understand?
Yeah.
An agreement has been reached, though, where you would be pleading guilty to what? The DWI?
Yes, sir.
Isn't that a class B?
No, it's
Class A?
enhanced.
A regular?
Or you regular?
It says lesser included. You know what? I've got Kim Wynn. This is Kong Wynn.
Yeah.
Kong Van Pat.
Kim, we already did.
Yeah. Okay, that's,
So Jimmy changed that for me. I was like,
that was the only
No, I
Vietnamese
didn't.
name we had.
Yeah.
It's like, okay.
Sorry. So
You were just checking us, weren't you, Judge? Thank you.
an agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison, that would be suspended and you would be on probation for 10 years. You would pay $1,000. There would be terms and conditions of probation, which are normal and customary for this type of offense, for a DWI. And you must, as a condition of probation, you will be sentenced to 10 days. Is it 10 days?
That's
Have you
right.
you will be sentenced to 10 days in the county jail as a condition of probation. You have to go to jail for 10 days. Do you understand? He has to go to jail. It's required under Texas law for all cases of a DWI third.
A procedure coming tomorrow.
Okay.
Yeah, we can do it later. I would request.
It can be postponed until he's able to do that. How long will he be unable to go to jail? When can he attend the 10 days, which is required?
Okay, the optical, can you take it in jail?
Yeah, you're allowed as long as you have a prescription.
Take it with you. Yeah.
Yes.
Yeah, that's no problem. How long, when can you,
Now.
a couple weeks, a week, 3 weeks?
Next week,
How about is 2 weeks good?
I can.
Okay, so he would check in. What's 2 weeks from today? On or before 6 o'clock PM.
June 9th.
Tuesday, though, today.
Yeah, that's right. That's right. Sorry.
Yeah, today's a Tuesday.
Would Monday be better?
I'm living it like a Monday. I apologize.
Think we all are.
Monday
Is
be better?
Monday or in 2 weeks, Monday or Tuesday, which is better? Tuesday. All right. 2 weeks from today, you must check into the jail on or before 6 o'clock PM. And you would have to spend 10 days and then you'll be released. If I follow this agreement, you have no right of appeal of your case. How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yeah.
And prior convictions of DWIs in 2008, I'm sorry, 2005 and 2011. Are those true and correct as they are alleged in the indictment?
Yes.
And are you pleading true and correct voluntarily because they are true?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that?
Yeah.
Did you understand it? Discuss it with your attorney? Are the contents all true and correct in State's Exhibit 1?
Yes.
State's Exhibit 1 is made a part of the record for all purposes without objection.
Okay.
Okay. This states that you are mentally competent to enter your guilty plea. And it is freely and voluntarily made. You understand what you're charged with. Your attorney has reviewed all of this with you. You are guilty of the offense charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true and correct, this says. Is that true?
Yeah.
State's Exhibit 1 is made a part of the record for all purposes, without objection.
Okay.
Is a pre-sentence report waived?
Please, John, yes.
I'm going to follow this agreement. And Mr. Palm, I'm going to find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
Yeah.
You are giving up your rights to a jury trial and the rights to the presentation of witnesses. You are satisfied with your attorney, and you are also guilty of the two DWI convictions in 2005 and 2011, as the indictment shows.
Yes.
And all of this is true and correct, so help you God.
Yes.
State's Exhibit 1 made a part of the record for all purposes. Sentence report is waived?
Yes.
All right. I'm going to find you were pleading guilty to paragraphs 1 and 2 of this indictment, which constitute a third-degree felony. You are mentally competent to enter these pleas today. State's Exhibit 1, admitted at this hearing, supports your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of DWI. I am going to follow this agreement. You are hereby sentenced to confinement in the institutional division prison for 10 years. That is suspended and you were placed on probation instead for 10 years. Please follow these terms and conditions of probation that the probation officer is going to review with you here in a minute. You must pay a fine of $1,000. You must have an auto ignition interlock system in any vehicle you operate. That's to test you before you start the car to make sure you're not intoxicated. Everyone with a DWI has to have that. There will be other terms and conditions of probation that the probation officer will review with you. Please make sure you follow these terms. If you fail to follow these terms and conditions of probation, your probation could be revoked. And then you could be sentenced up to 10 years in prison. We don't want that. So make sure you're always sober when you drive. The probation papers are given to this lady. Please speak with her. And she will go over all those terms and you're going to need to translate with her and Mr. Palm.
Yeah.
Mr. Palm, do you understand what has happened today, sir?
He's on his medication. If he get in, how do we?
Yeah, he has to have a prescription. Okay, he needs to bring that when he checks into the jail. And what they'll do is they'll keep it and they administer it to him. They have to give it to him because they don't want, if people kept it in the jail, they give it to other people. We don't want that. It's in the bottle. He has to bring that with the prescription. God bless you.
The prescription is, he's going Houston, Winston, Texas.
Get them to send an email with a prescription or something and print it out, something to verify that it's prescription.
Yeah, work with Mr. West. He's the attorney. If you'll tell him where the prescription is, they can fax or send something to him and he can print it out properly. And if there's a problem, let me know.
Yeah.
Okay, he needs to report
By next 2 weeks from
June
today.
10th.
Yes.
June 10th. That's
Yeah.
okay.
When you check in jail, in
At the jail, yes.
Jefferson County, yes, ma'am. Here, please see the probation officer. Thank you. Thank you. Ciao. Anything else? We're in recess till when?
1:30.
1:30.
Help me if I figure it out today, because I tried. Oh, okay. Good morning, sir. You Christopher Henry James. And Mr. James's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, state's ready, but Mr. Lewis has discussed it with me.
Judge, I'm not ready from the defense end, Judge. I have a trial that's gonna start Thursday. Supposed to pick a jury Thursday in the 496 in Harris County. Start testimony on Monday.
Okay.
And I anticipate it is going. I don't see it being worked out.
Okay. If for some reason it does not, can you be ready?
It would be tough, Judge. There was some additional information I did receive a couple of weeks ago. Well, it became available a couple of weeks ago. Was the rest of the on-top tax reports and things.
Okay.
Right.
All right. So what I'll do is take that into consideration, and then if something changes, would you let me know on Thursday if for some reason that case works out?
Oh, I will, because actually I'm getting ready to head that way now for pretrial conference day as well.
Okay. Well, yeah. So let us know this afternoon. If something happens today and that's going to go away, and then you would have all week to prepare, then we'll go ahead and I'll number it. Obviously, if you're getting ready for that other one, we'll reset it. But if I have to reset it, Mr. James, we'll reset it as quickly as we can, so that we can get your case tried. Okay? All right, yeah, just let us know this afternoon.
No problem.
Thank you.
Thank you, Your Honor.
Mr. Parker, on Devonta Anderson. 2 cases. Good morning.
Diamond and Anderson.
Is there any kind of agreement or?
Last time we went through some of the motion, he pled true to some of the. I think he, well, no, he didn't. Okay. To me, he did.
Good morning. Are you Devonta Anderson? And Mr. Anderson, in cause number 23 DCCR 0288, there's a motion to revoke probation filed, and same in 23 DCCR 0290. And what is the announcement?
Your Honor, we don't have an agreement. I believe it's probably best to go through the motion.
Okay. Give me just a second to get those. Can you print the second one?
And I don't know if I have the amended one.
I don't see an amended one.
I don't know. Okay, I thought we said well together.
I think we'll mix it up.
Okay. Okay. I'm good.
Give me just a second to get them both pulled up, printed out. Mr. Anderson, while we're waiting on those to print out, would you, best you can, raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right.
I think they're same violations in each case.
All right, thanks. All right, and will your client waive the formal reading of the motions in each case? Mr. Anderson, in cause number 23, DCCR 0288, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 24th of 2023 for the second-degree felony offense of sexual assault of a child, and that was a 7-year deferred probation. Is that correct? And in cause number 23, DCCR 0290, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation that same date, October 24th of 2023, for indecency with a child by sexual contact, a second-degree felony, and that was also a 7-year deferred probation. Is that correct? Each of these motions allege that you violated your probations. Count 1 in each motion alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of November and December of 2023, and then January, February, March, April, May, and August of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 in each case alleges that you failed to provide verification of performing your community service hours. Is that true or not true? It just says that you didn't give proof that you did your community service hours that were required. Did you do that?
I did some.
Okay, we'll just put a not true on that one. Count 4 alleges in each case that you failed to complete a substance abuse assessment and follow any recommended treatment plan. Is that true or not true? Count 5 in each case alleges that you provided urine samples April 23rd of 2024, August 13th of 2024, September 19th of 2024, November 25th of 2024, and December 5th of 2024, and then January 30th of 2025 that all tested positive for marijuana. And is that true or not true? Count 6 alleged that you failed to successfully complete an approved sex offender treatment program. Is that true or not true? Says that you were unsuccessfully discharged December 6th of 2024. Okay. Count 7 in each case alleged that you failed to submit to the polygraph examination as required December 6th of 2024. Is that true or not true? Count 8 in each case alleges that you failed to not enter a sexually oriented premises in that you admitted to your Harris County officer that you went into an adult bookstore. Is that true or not true? I'm sorry, not true. Count 9 in each case alleges that you failed to not use any online services, social media, or anything like that unless approved, in that you admitted to your Harris County officer that you accessed the internet without monitoring software. And is that true or not true? Count 8 alleges in each case that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true in each case to counts 1, 2, 4, 5, 6, 7, 9? Would you, Mr. Hoffpower,
Motion to amend that to 10 instead of number 8.
any objection to that?
Repeat that, Judge?
The number,
Oh, no.
it should be
Okay,
number
yeah.
10,
I'm
and it
sorry,
says
yeah.
number 8. Any objection to him orally amending that? All right, so that, I'm gonna change that. In each case. Okay, so did you enter your pleas of true to those counts freely and voluntarily? And because those counts are actually true. All right, I'm going to find in each of your cases that you entered your pleas of true to counts 1, 2, 4, 5, 6, 7, 9, and 10 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for a sentencing hearing so that I can get an updated pre-sentence report done, or an updated report done by the probation department. Your attorney will be able to present any evidence on your behalf, and so will the state, and we will come back for a hearing at a later date. All right, you can go back with the bailiff. Unagreed.
I'm gonna have.
Hold on.
Right here.
Maria Chavez.
That's. I'm sorry.
We'll reset it once we.
Okay.
Being sentenced in the feds today.
Okay. All right. Thank you. Traylon Martin, Mr. Parker.
He's refusing to sign. Traylon Martin. The rejection.
He is going to
He
sign.
refused to sign.
He
the
did.
rejection.
Okay. We'll just go through. Can I get a rejection? One of the printed ones, please, ma'am.
He wants to hire somebody.
Good morning, sir.
Good morning.
Are you Traylon Martin?
Yes, ma'am.
And Mr. Martin, in cause number 25 DCCR 0270, you're charged with the third-degree felony offense of obstruction or retaliation from January 29th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And what is the offer that's been made?
2 years TDC, Judge.
And so, The state has offered, if you want to enter a plea of guilty, a 2-year term in prison, which is the minimum. You have every right to reject that and have your case set for trial. But I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial, or do you want to take that offer?
Can I ask one simple question?
Sure.
I'm just trying to ask, I watched the video,
Uh-huh.
how the case started, and I was the one that was set up with it, so.
So that's what a jury's for. If you don't think you're guilty of what they're said, that,
I mean,
then
I can't assault you if I'm already detained.
I don't need to know that. That's what a jury's for. Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
So,
And, just for the record, I've explained this to him. I've shown him several different videos. Some of them are more relevant than others, and he indicates some things that there may be other videos out there that I don't know about. They're not there as far as discovery. He's indicated he wanted to hire Marcia Norman, and I told him you can reject it. If you're not guilty, then don't plead guilty and reject it, and if you can still hire Marcia in the meantime.
Mr. Nichols, is there any other discovery that you anticipate?
I didn't see any in the file from Ms. Volpino, anything else, Your Honor.
Okay.
I know she made the offer. I know that he had got a reduction on the same charge a year ago, so I don't see any reason the offer would change. They did ask for probation this morning. I did not change Ms. Volpino's offer.
Okay. So, Mr. Martin, if you don't want to accept that offer and you want it to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
Yes, ma'am. I just want to ask, I've been trying to get a job and work to see if I can just see if it'll help me out with my time as a trustee.
Okay, none of that matters right now, okay? Because here's what we're not gonna do. We're not gonna put your case on the trial docket so that you think you can get some time under your belt, and then you're gonna plead guilty later, because after today, I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time. Either you did it or you didn't do it, and if you didn't do it, then you can sign that and we'll get a jury to decide, but I don't want you to think you're gonna come back in here later and say, oh, I wanna take that deal, because it's not gonna happen. All right?
Am I eligible for parole?
I don't know when you're eligible for parole. I don't know how much time you have.
I never had to do this. That's why I'm asking on.
I know, and that's why Mr. Parker's, nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not us. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on.
I've explained to him how much time, based on what he's told me he has and how much time I think he'll have to do before he's eligible. But again, I told him I can't guarantee that. But if you're not guilty, then don't sign it. You please reject
So
it.
it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial, or you plead guilty and.
I'm gonna go ahead on the sign.
Sign what?
I'm not guilty.
You can't say you're not guilty and then sign for time. It doesn't work that way. Because what happens, for obstruction, it's not assault on an officer. It's obstruction or retaliation, which is different. And there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it.
I want to go to trial.
Okay, sign that for me, rejecting that plea offer then.
Okay, where?
Look, sir, pay attention, sign that.
Okay, where the home at?
Right there, just defending right there.
Okay. I got a hospital building. I got evidence in the free world.
So real quick, hold on before you go back. Mr. Parker has been appointed to represent you. With your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes,
All right, so I'm going to appoint a new attorney today. They'll be out to see you very soon. Huh?
can I pick one or y'all?
No, you're gonna get whoever's next on our list. If you have some, whoever's next on the list.
You can hire whoever you want.
You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready, okay?
Yes, ma'am.
All right, you can go back with the bailiff. They let them wear rings? They let them wear rings in jail? They let them wear rings in jail? I just feel like that would be, if you hit somebody, that would be a whole issue. A ring, like a big old gold ring. That confuses me. That makes no sense to me at all. Mr. Wilkerson on Rebecca Rideau.
Good morning, Your Honor.
Good morning, how are you?
I'm doing well. I'm working on the paperwork right now.
Oh, all right, hang on just a second. I will recall it when all of that's taken care of. Thank you. Mr. Burbank on Chase Bro. Oh, did, okay, I'll hold it till the paperwork comes.
No, it's.
I'm sorry, I just hadn't sent it, Good morning.
I know, right, but I got a bad one. He's just not using it.
So is that Chase Bro?
No.
Chase Bro?
He just was here fingerprinting.
Okay. I'm sorry,
One more thing for him, please, Sarah will. This is Mr. Brown.
Good morning, sir. You're Chase Bro?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Bro, in cause number 22-40132, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 17th of 2022. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And why is there a difference between the rejection and what we've got today?
Your Honor, this is a case that, in all honesty, we shouldn't, I am of the opinion that we shouldn't be using or wasting a jury on unauthorized use of a motor vehicle case. The defendant's taking responsibility, given his criminal history. I think 180 days is sufficient. I'd much rather focus on the rapes, robberies, and murders. Try as we do in these cases.
I don't disagree. I just think we need to do that when we do those rejections. All right. So do you understand if I follow the agreement that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I'm required to ask everyone that.
I think I'm ready.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Bro is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Burbank. All right, good luck to you, sir. Thank you, Mr. Coleman. Thank you, Mr. Burbank. And then you've got Augustus Simon, Mr. Burbank.
He's signing up right now.
Okay, I'll hold that till it's ready. And we're resetting Mr. Harris.
Yes, he's present, and I agree. One more resetting, Judge, to see if we can get him to Harris County.
Oh, this is that one?
He's got a capital murder.
I know, but I said last time we weren't gonna wait.
It's Ashley's case.
Did Ashley leave a note? Because we've been.
She did, she messaged me over the weekend, and I'll relay that.
I mean, either they're gonna come get them or they're not, and this has been months. Okay, hold on. They issued a bench warrant last week.
Right, it was more of just getting them to do it, Judge, with that. They finally did it, but it was only last week.
Okay. All right, so it sounds like there's a new bench warrant last week, so maybe they'll actually come get them.
That's the intent, I hope.
Okay. Who's this? Okay. I don't have his paperwork yet. All right. How many are y'all doing on Rito?
So we're doing 4 unagreed pleas and 1 rejection.
So the rejection. What's the? I mean, so that means y'all go, I mean, there's already been a rejection. They're set for trial, so.
Yeah, so basically.
I'll call y'all back up in just a second when I get the paperwork. Okay,
State's prepared for trial.
okay.
And so basically, she's willing to plead guilty on the 4 theft offenses. The other offense, I have some misgivings about, but we can only take that up at the appropriate time. So,
Judge, I am of the opinion that if she won't plead to all of the cases, I just soon file a motion, try them all, file a motion to consolidate at least 2 of those cases that came out of the same occurrence. I suspect if we get the resolution that we're wanting out of those 2 cases, it will take care of those remaining cases.
Well, I mean, I guess there's no reason, can she not plead guilty? Are they just open to the court?
right, those 4 thefts are open to the court. The tampering stems from having clothes that she stole under her clothes when she was searched at the jail. So that's the theory under which the prosecution is seeking the, obviously, I think that creates issues. Anybody who had drugs in their pocket and didn't give them to officers then could likewise be charged, but I also don't believe it's.
And they charge them with possession of it in the jail all the time after arrest.
Right, but
I
not
don't know about
tampering
tampering.
with evidence. So
She concealed it, is the state's
That's fine. I don't mind whatever y'all want to do, but I think if, hold on a second, because if she pleads guilty to the 4 and I reset it and get a pre-sentence report and do whatever I do, then would that potentially resolve, I guess, depending obviously on what I would do? Because,
I don't think so, Judge.
I mean,
The tampering has a heavier hammer, higher punishment range. And I think given her criminal history, she should be facing that.
okay. I'm just trying to think. I mean, she has every right though to plead guilty, right? But but if you want a jury,
I have to wait. This is not the kind of case where I would refuse to waive my right to a jury trial.
okay,
What's complicating this case is her history, Judge, and I have it here, she's got numerous previous deaths.
oh no, I'm looking at the indictment. But on those, they're all state jails. Is that correct? Even though, because all the priors were enhanced to state jails.
That's right. And I made an offer earlier on that would have resolved all of this. They rejected it, and we ended up filing a 3rd-degree tampering as a result of that rejection. So the defendant could have avoided being in this situation had she taken responsibility of it.
Okay, so do we want to go ahead and go through with these pleas then? And then it'll get numbered I mean, the cases are falling apart next week. We'll see what happens, but we could try the tampering.
State's ready on the tampering, Judge. I don't know what the court's thoughts are on letting the defendant just plead. Well, I guess that's not what she wants to do. I was thinking maybe just plead guilty to the.
If she wants to plead open to me,
you. Okay.
that's what this looks like, the paperwork that's been done. So let's get the pleas done. And then if it goes to trial on the other one next week, great. If not, it'll probably get sent, these will be sentenced before. And if there's any change in circumstances based on that, then we'll.
And Judge, we're certainly not opposed to a trial before the court.
I'm sorry.
Not trial before the court.
A bench trial.
Bench trial.
On the tampering?
Yeah.
Well, let's get through these pleas and then y'all can talk about that. And if for some reason, if it's not reached next week and y'all both agree to a bench trial on that, then we can find time. I wouldn't think that would be something that took a long time. So we'll, but you'll need to talk to your client about that, obviously.
Yes.
Okay, Miss Rideau. All right, you're Rebecca Rideau, and will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Give me a minute to get. Ms. Rideau, in cause number 23 DCCR 0928, you're charged with, hold on, let me get to that again. If y'all want to print those other ones, it might be convenient. The next three, 210607 and then 1925. All right, in this case, which is 23 DCCR 0928, you're charged with a state jail felony offense of theft of property with previous convictions from November 21st of 2022. The indictment alleges you were previously convicted of theft September 11th, 2010, September 17th, 2010 in 2 different cases. And then again, October 26th of 2015. And then September 21st of 2021 in 3 cases on that date. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all those prior offenses and convictions true?
Yes, ma'am.
And then in cause number, they printing or do you want me to pull it up? In cause number 23 DCCR 2106, you're also charged with theft of property with previous convictions. The offense date from this one is September 23rd of 2023. It alleges those same prior offenses, and how do you plead to that charge? And are those prior offense convictions true? And did you enter your plea of guilty freely and voluntarily? And because you actually did what they charged you with? And actually, that indictment, I said the 23rd day, it has been indicted, it has been amended that the offense date is the 22nd day of September. Does that sound correct? Okay. And then in cause number 23 DCCR 2107, you're also charged with theft of property with previous convictions from October 2nd of 2023. That indictment alleges those same prior offenses, and how do you plead to that charge? And again, are you pleading guilty freely and voluntarily? And are all of those prior convictions true? And then finally, in cause number 24 DCCR 1925, you're also charged with the state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges those same prior convictions of theft, and how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they've charged you with? In each of those 4 cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it's my understanding you have no agreement in your case, in any of these 4 cases, and so you're just pleading open to me. Is that correct?
Yes, ma'am.
I want to make sure you understand your cases are set for trial to begin with jury selection next week. You have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me, and is that what you want to do?
Sorry to interrupt, Judge. The state has filed a motion to accumulate, we will be asking the court to accumulate those cases to the extent the law allows.
Okay, because they're all different offense dates, correct? Or at least,
Some of them are.
no, I think they are, nope, they're all different offense dates.
So we will be moving or asking the court to accumulate those sentences.
And have you gone over that with your client?
Yes, Your Honor, she's aware that the state's asking for the charges to be stacked.
I guess part of my issue with this is, let's say I do something that Ms. Rideau doesn't like, and then she has the ability to appeal, and I don't guess there's really an appealable matter, but you never know. I don't want to waste a bunch of time and then us be coming right back here, but.
And Judge, I've looked for the path of least resistance to resolve these cases. We are in the situation we're in because it's defended.
No, I don't disagree. Well, we'll get where we'll get. All right, so you understand that I can give you anything from probation up to 24 months, up to 2 years on each of these cases. And I can stack those sentences on top of each other. Do you understand that as well?
Yes, ma'am.
And you want to go forward with these pleas and get the sentencing on these done. Is that correct?
Yes, ma'am.
Okay.
In addition, Your Honor, my client has asked, and I know the response to the court given the prior answer, but I am required to ask that the court, she's asking the court waive pre-sentence investigation on these and proceed with sentencing. She also would like to be released for her, I believe it's daughter's graduation.
Yeah, Saturday from Westbrook.
State's posted it, Judge.
No, that's not happening. No. All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history, obviously there's a substantial amount of history. And so I want all of the information. So we will get a pre-sentence report done in all of the cases. And I'm not doing anything with the bond other than potentially raising it to make sure that we're where we need to be when we need to be. So That being said, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Rideau is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning, so you never know. You guys will know today after docket what the trial order is.
One final thing, if I may, on the tampering, Judge, it's filed as a 3rd degree, but I filed a repeat offender notice seeking to enhance it to a 2nd degree, given the defendant's previous robbery conviction. So I just want to make sure that all of that's.
Why did you put the tampering on me when you put the death on me?
Look, we're not, this isn't a conversation.
I'm sorry, yes, ma'am.
It doesn't matter, and they didn't put anything on you.
I mean, that's what I'm saying.
Okay, listen.
I don't understand how is it tampering? I mean,
That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure, with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of a 2nd degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Okay. And so I will number that case for trial for next week. All right. You go back with the bailiff.
Thank you, Judge.
Thank you. I'll let y'all know as soon as docket's done what the trial order is.
Thank you, Your Honor.
Yes, sir. Good. Then I don't have to worry about those. Okay. Good. Thank you. Okay. I really didn't write on these. Should I though, since she pled true to all of them? Maybe so. Did I save this? I don't know if I did the first one right either. Let me look real quick. Yeah, this has been going on forever. This may be a, I wonder if drug court has something like this, maybe on a.
Yeah, I'm sorry, Judge.
No, it's fine. I'm not opposed to doing it, obviously. But just based on the nature of that offense,
I think it would be appropriate.
that might be one that we could, so it doesn't sit around and wait for all the other big stuff. Let's see what it looks like after the docket, and then I'll contact them and see if they have a. So I'm right, oh. Uh-oh, do y'all want to text him real quick? I mean, he can do it when he comes back for sentencing, but.
Or even Monday.
I got it. Okay, so I did the first one where it was supposed to be done, and then, okay. Mr. Burbank on Mr. Simon, Augusta Simon.
It must be taking too long.
Why though? I mean, it just slows down everything. Just give you a minute. Good morning, sir. Are you Augustus Simon Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Your Honor.
Mr. Simon, in cause number 23 DCCR 1542, you're charged with the first-degree felony offense of murder from September 9th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over it with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney, you will be waiving or giving up any right to appeal? So if I take this plea agreement, which is for 40 years in prison, you can't.
It's a cap of 40.
Oh, it's a cap of 40. I'm sorry. So as long as I don't give you more than 40 years, you're stuck with whatever I give you as long as it's 40 or less, and you can't change your mind later. Do you understand?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it also looks like that as part of that agreement, the state is going to dismiss cause number 23, DCCR 1543, which is the tampering with physical evidence. Is that your understanding? So I want to make sure you understand you have an absolute right to have a jury trial. In fact, your case is set for trial for next week. And you could have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And again, you're leaving it up to me. And as long as I stay within that plea range of 40 years or less, then you're waiving your right to appeal. And is that what you want to do?
Yes, ma'am.
All right, state tenders number 1.
No objection, state's fine.
It's admitted. Is there any evidence that Mr. Simon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Anything that you think is important, get that information to Mr. Burbank and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff. Yes, sir, thank you. Ms. Holmes, you have Charles Elam, cause number 15-22022. Good morning, ma'am. How are you? Good morning, sir. You're Charles Elam?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will.
Let me get it pulled up correctly here, just a second. All right, Mr. Elam, in cause number 15-22022, I have a motion to revoke your community supervision. Shows that you were placed on probation June 27th of 2016 for the 3rd-degree felony offense of driving while intoxicated, 3rd or more, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation by committing the in count 1 by committing the offense of driving while intoxicated, 3rd or more, March 7th of 2023 in Chambers County, Texas. And is that true or not true?
True.
And count 2 alleges that you failed to never become intoxicated or under the influence of intoxicating substance, and that you were intoxicated March 7th of 2023. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I have some documents here on the computer that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Elam is not competent?
No, Your Honor.
All right, give me just a second to get this pulled up. I guess this was all done before we were putting in PSIs for me to see.
He's been in custody since 2023. We actually had to bench warrant him because he's been in TDC.
He has.
He was sentenced in Chambers County already to TDC.
Okay.
You have the criminal history, Your Honor?
Yeah, I just kind of wanted to make sure.
This was, he had a DWI third that he got put on probation for and revoked. The offense did that was 2002.
Okay.
And so that's why I agreed to probation on this one, because there's about a
Gotcha.
15-year gap.
Okay. All right, then, Mr. Elam, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Good luck to you, sir. You can go back with the bailiff. Edward Miller, Ms. Holmes.
I just need to point something out, and I did not say anything. It was a cap. And I didn't say touch, so.
You should have, and you should have said, I told you so, and give them the 8. That's what you should have done. Huh?
70 years old.
Well, stop driving.
73.
Stop drinking and driving.
I know, crazy.
Huh? Doesn't matter how old you are, at some point. You would think you'd figure out how to
Yeah.
drink, but stay home.
And that's what I tell them, look, just drink at
You can
home.
drink at home. Nobody's
Why do
telling you
have to
can't drink
go
at home.
somewhere? Drink at home. Jeez, why is that so hard? Makes no sense.
And we're going, it looks like on a lesser attempted.
Yes, ma'am. Right here. Wayne. You're fine.
All right, are you Edward Wayne Miller? Can you answer out loud for me? Yes?
What's your name? What's your name?
Okay.
Is there a,
I have debated, and I've told him, I said, if I need to do competency evaluation, then he tells me, he said, oh, no, I'm fine. It's like he switches. So it's like
Okay.
at one moment, he absolutely does not understand anything. Then when I say, okay, let me get him evaluated, then he's like, oh, no, I'm confident. I understand.
well, we're gonna do an evaluation. I'm gonna reset it. I'm gonna, I feel like I have to just based on that. And so I'm gonna delete this paperwork and we'll have the, somebody get him evaluated for competency as quickly as possible. You can go back with the bailiff.
Okay.
Good morning, how are you? Did you need something? You're not on my docket.
I'm not on your document, but I do need you for a second.
Uh-oh, what you need?
or not she shows up and you and she kind of finalize your arrangements. So we'll put you on the second call. You might want to call her office to see for sure that she's coming and that she understands she's representing you. Still working on him? All right. While we're waiting on Mr. DeMoss, I'll take up the next case. What are we doing with these jail cases? Are we doing them all by Zoom? Oh, all right. Then on page 1 of the docket, 2023 CR 21 State versus Christopher Wade Bateman. It's Mr. Brown's case.
$519, I think, which was Mr. Brown represents him, and he was here, but not Mr. Bateman. I don't think he had had contact with Mr. Bateman, and I do believe at that point in time, you issued a capias with a new bond for $500,000.
Right.
So I
Your
can,
motion to revoke bond is granted, the bond is revoked. All right, bring out Mr. DeMoss. All right, Mr. DeMoss, we're here again on your motions that you have filed in this case. So that I can understand better, I know that you have filed a motion to compel your lawyer to, or the public defender to file a motion for your post-conviction release. I think the way you have it styled. What exactly is it you're saying? And I understand before when we were here, my argument or my response to your argument was if you feel that there is an issue, then you need to have your lawyer file something. And I don't know whether or not the public defender's office has looked into this at all. Mr. Talbot, can you address this issue with Mr. DeMoss? Let's go ahead and turn your microphone on there on the table and let's let you deal with it there.
Yes, sir. Thank you, Your Honor. On this, my understanding is that first, the public defender's office no longer represents Mr. DeMoss. And then second, with respect to his, I guess his goal here, all that the public defender was tasked with doing, I think by the court last time this was addressed, was to explore the possibility of whether an agreement could be reached on this for an agreed PCR, I think was the language. Mr. Mitchell explored that with the state. There was no agreement about resolving this to Mr. DeMoss's satisfaction, and therefore that concluded that effort.
Mr. DeMoss, what is it that you say is incorrect? Now, what I have attached to your motion is that you entered a plea of guilty back on March of 2024, March 12th, to a count 7 of an 8-count indictment, evading under TCA 3913-503, and you received a sentence of 2 years to serve in the Tennessee Department of Corrections, consecutive to a prior case of 2016 CR 346. and you were given credit for time served, and that credit was set out at March 17th, 2022 until September the 13th of 2022. What I'm not clear on what exactly is it that you're saying is incorrect or something that you believe that this court can address.
I'm gonna make it easy for all of us. I'll go home in 10 days off this case. So
Is that microphone on? All right, step up to the microphone.
I'll go home in 10 days anyways on this case. So I just want to just let you know that I've done 4 years on a 2-year sentence on this right here. And last time whenever we talked, Mr. Mitchell was supposed to do a post-conviction release that you told him to get with the DA, and he never did file. And whenever I went to court back in March or April in front of Wallace, he told him that it was denied. But whenever I asked him for a copy of it, he refused to give it to me. But that's fine. I go home in 10 days, so, you know, we don't
In
even
10
have to be
days, you're
here.
going to be released.
Yes, sir.
All right, well, let's just, good luck to you.
Thank you, sir.
All right, so whatever that motion was is dismissed. All right, if we have other inmates, let's go ahead and bring them out one at a time, please. Good morning. What is your name, please?
Heather Gamble.
Heather Gamble. All right, Ms. Gamble is on page 6. Your lawyer is in the middle of a trial, so he was going to try to come in on Zoom. We're going to see if he's in the waiting area. We can go ahead and address your case.
Sir, he actually told me that Roger Wainick was going to stand in for him for me today.
All right, so Mr. Wainick is, all right. Mr. Wainick is in another court in another county, but is coming, so we'll just have you step back and we'll bring you back when Mr. Wainick is available.
Yes, sir. Thank you.
All right, thank you. On the iPhone there, can you tell me, unmute your device and can you tell me who you are?
Hi, yes, sir. My name is Deanna Schaff. I'm with Cross Star Life Recovery Program.
Okay. Are you here regarding a particular case?
Yes, sir, I do believe so. Mr. Christopher Health.
Hostiles be available in case we were to have a hearing on Mr. Health?
Okay.
I don't know if we are or not, Judge, but so.
All right, ma'am, Mr. Health is here on the docket, but we are not sure if we're going to have a hearing where you may be required to testify. So if you want to let us put you back in the waiting room area and we'll send you a message if we're ready for you. Okay, that way you can try to go about some business.
Okay, yes, sir. Thank you.
All right, thank you. All right, Ms. Teresa Kathy is on page 2. Kathy, you are here today to be, I think this is a review regarding the rehabilitation.
Yes.
Anything to report about that?
Sir, it appears that Miss Kathy left the program. Hope Center, I believe it was. Yes. There's a hair follicle drug test that I would like to ask probation. So we could come back to this later in the docket.
All right, she was found guilty of violation of her probation back in March of 2024, and a sentencing hearing was reset for September the 25th of 2024. She was furloughed to long-term treatment, and it was required that she complete that treatment to be resentenced. There were reviews that had come every few months. And she has now been discharged from that without successfully completing the program, correct?
That's correct, Your Honor. She did complete 11 months, however, and she does contest the basis of her running afoul of the program.
We're ready for a sentencing hearing then?
Your Honor, if I can set this to next VOP day.
Problem is going to be, I have to be the one to sentence her because of the fact that I took the original plea. So it'll have to be September. So we'll reset it for September.
Can we come back to this today, this morning?
We'll put it on the second call.
Thank you.
I want to make sure that she understands, Ms. Kathy, you entered a plea of guilty and you were found guilty of violation of probation. It was reset for sentencing to allow you to try to complete a long-term program. And so now that you're out of that program, this really basically comes back before the court for sentencing. So you need to understand that when you talk to your lawyer. All right, bring out the next inmate. While we're waiting on the next inmate, we'll go to regular call. State versus James Adam Benner. This is also the public defender. James Adam Benner. The hearing on a community corrections.
Your Honor, he's on bail right now, and he texted me this morning saying that he's on his way. If we could second call that, that would be appreciated.
Does he know what time court starts?
He does, Your Honor. Sir.
I'll give him a second call. Officer Perkins, just bring them out as soon as you get one ready, but I'm going to take up some of these that are not in jail while we're waiting. Looks like the next one is 2021 CR 238, State versus Morgan J. Francini. Public defender.
Your Honor, Mr. Franceschini has been in Synergy for the past little bit. Need you to sign right here. He will be admitting that he violated his probation. He will be reinstated to probation with a zero tolerance monthly drug screen. And state has requested there be no IOT report.
I believe this was set for a sentencing hearing and review. So he's already been found guilty, correct? All right, Mr. Francini, raise your right hand. Let's place you under oath. State your full name for the record.
Morgan Jared
You
Francini.
push that microphone up so you don't have to bend over. There you go. Mr. Francini, you are here today to be sentenced on a probation violation that you previously were found guilty of. It is my understanding that you have now reached an agreement with the state as to the disposition. You understand, having been found guilty and pled guilty to the charge of violation of probation, you're still entitled to a sentencing hearing where the state would be able to put on proof and you would be able to put on proof regarding what the possible disposition of the case would be. Do you understand that?
Yes, sir.
You understand if we had that sentencing hearing, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. Do you understand that?
Yes, sir.
You understand that by agreeing upon this disposition, you're waiving your right to the sentencing hearing and to the appeal of that issue.
Yes, sir.
Is that what you wish to do in this case?
Yes, sir.
All right, then upon your having been found guilty of violation of probation, and by agreement with the state, you'll be, based upon your successful participation in a rehabilitation program, we will reinstate you to active probation with a zero tolerance for any drugs, positive drug screens. That means one positive drug screens, you're going to go right back to jail. You understand that?
Yes, sir.
All right, there will be monthly drug screens and no IoT reporting. It's the judgment of the court. He needs to continue seeing the probation. Thank you. We're ready. All right, Ms. Sweeney is on page 19.
Could we pass this to the second call?
Is this the, yes. We'll put it on the second call. Mr. Locker. Yeah, she talked to us. Any about it. Just if I get to it and I don't remember, remind me. Thank you. All right, Ms. Sweeney, we're going to pass you to the second call, so we'll come back to you after Mr. Locker's had a chance to talk to you. All right, next case that's on bail would be State of Tennessee versus Zachary James Fulton, 2022 CR117. Mr. Ryan Duggar is the attorney. Actually, this is a successful completion or termination of community corrections. Is that the only reason it's here today? All right. Mr. Fulton, it appears that you have successfully completed that portion of the community corrections program that you were sentenced to, and now you'll be transferred to regular probation, but you understand this is just a step in the right direction. It's not the end of your probation. You will now be on regular probation.
Yes, sir.
And if you violate that probation, we'll be right back in here and you'll be going to prison. So you understand that?
Yes, sir.
Apparently you're doing well, so keep up the good work, okay? And I'll sign the order.
Yes, sir. Thank you.
Thank you. Make sure you stay in touch with your probation department.
Yes, sir.
Twenty 284 State versus Brittany Noel Haddock, public defender.
I attempted to call Miss Haddock a couple weeks ago. Haven't heard anything from her.
We have a bond for her.
She was on furlough.
That's correct.
Still on furlough.
I believe so, because she already admitted.
All right. Issue a capias and hold for a hearing. All right. We'll go ahead and issue the capias for her. All right, go ahead, that's fine. Bring out the inmate.
Hi, Alan.
Mr. Allen's on page 1. Alan, you're here to, because you have a violation of probation, public defender has been appointed to represent you. Is the public defender ready on this? Ty Allen, page 1.
Second call, Mr. Honor, so I can talk to
All right. 2017-0-186 State versus Ryan R. Hall. I assume that would be for final bond forfeiture. Mr. Tummons?
Yes, sir. I'm prepared to pay that this morning, Judge.
All right. Final forfeiture is entered. Thank you for being here and being ready to pay that in. Thank you.
Yes, sir.
Twenty 336 State versus Gregory Arnie Hansard.
That's a status on his 2025 indictment, and we were going to ask the court for a date to hear the motion that the defense has filed. It's a
What
motion
about
in limine.
Thursday? It'll be a trial where? Okay. We're actually going to try a case in Houston County?
Sir.
Your Honor, this case is set for trial September 24, a day prior to trial. Even in September, it would be. September's good.
I thought we had set these Hansard motions on the 21st day of August. Pardon?
We have Bucciarelli motions that day.
That's what I'm getting at. I have it penciled in on my calendar that the Bucciarelli motions would be here, and also that I penciled in Hansard, and that may be just a day that I had thought would work, but we'll put your motions on the 21st day of August here in Courtroom 5 of the Justice Center.
Thank you, Your Honor.
If we're ready on an inmate.
Good morning, Judge.
Good morning. All right, this is Juan Esteban Brooks, and this is a hearing on the violation of probation. You have previously been offered to have an attorney to represent you. Do you not wish to have a lawyer?
No, sir, I'm go pro se.
All right. Is the state ready on this hearing? You are here today because it's alleged that you were placed on probation on or about December the 4th, 2024 for the offense of failure to report, or I'm sorry, you were placed on probation.
It's all junked up, B-Dog. I had escaped from the Hope Center 11/21/23, and I got from Bend Engine, the sheriff had a release date of 11/25/24. So when I came into my plea with my elbow counsel, Matthew T. Mitchell, he gave me a suspended to probation, but it was, I had already did my 11/29. I had completed my sentence. So it was just a misunderstanding of paperwork. So I never showed up for probation, being that the sheriff gave me my 11, I was already serving 11/29. So it was just a misunderstanding. So when I got my case dismissed from a couple of weeks ago, my theft of property from Judge Marshall, him and the DA came through for me and gave me a dismissal. So I just wanted to clear up today that so I could go home for my VOP already served on misappropriation of paperwork.
All right, well, listen to me as I explain
Yes,
this,
sir.
okay? What I have before me is a violation of probation warrant that was filed on April the 28th of 2025. It alleges that you were placed on probation for escape on December the 4th of 2024, and that you were for a period of 11 months and 29 days. And part of the grounds was that you had not reported since your release from jail on December the 23rd, 2024. That's one grounds. But listen,
Yes, sir.
On the last grounds, it says that you were arrested for theft of property in Dixon County on April the 22nd of 2025.
Amen.
That would also constitute a grounds for violation of probation.
Amen.
And what I want you to understand is that I understand your explanation for not reporting or whatever the situation may be, but that is a separate grounds that you were violated your probation by being arrested on a new offense.
I got it dismissed.
All right. So does the state have any input in this particular situation? I'm sorry, he pled to what?
I just need y'all to let me go. It was just a misappropriation paperwork. We just gonna cut them on loose.
His point is that he's given some explanation for why he didn't report, and he says that the new charge has been dismissed.
Snow.
You be quiet while she's talking.
Yes, sir. Snow. Thank you, Lord. Officer Snow, will you let the judge know that I got my dismissal last week? You didn't?
You're gonna call him as a witness?
No, he let me know
I
last
understand,
week.
but you're winking at him and saying, would you let the judge know something? If you're gonna let the judge
I'm
know-
sorry. It's only when I got the voucher for me when I got on the bus to go home. Snow had let me know. Snow, you would say that if I call you up here, you would let me know that I had a dismissal.
Who is this probation officer?
Ullery.
Come around.
Here we go.
What are you saying uh-oh about?
Leather boots.
All right. My understanding is that I'm just gonna ask you some questions. I'm not calling you to testify just yet. Just stand right there. You don't have to go anywhere else. My understanding was that part of your original basis was that he failed to report.
Yes.
The second was that he had this new charge. I'm now being told by both him and the state that the new charge has been dismissed. It might be subject to reinstatement, to being brought again. Were there any other issues with his probation other than the fact he didn't report once he was released? Okay. All right, thank you. You can go back over there if you want to. You don't have to testify. All right. Do you understand that you didn't ever report to probation? I understand your reasons why, okay? So if I credit you for telling me the truth about that, then the only thing that I would be prepared to do today would be to reinstate you to probation and extend your probation for 11 months and 29 days, but you would be released. Now, that new charge that you're talking about that got dismissed.
Right.
I don't have anything to do with that.
Okay.
You understand that?
She's okay with it?
Well, she's not okay with it because she doesn't have anything to do with it either.
Yes, sir.
But what we'll have to see is whether or not that criminal charge comes back.
Got you.
But today, the only thing that I would have,
Send me home.
you know, that against you for your violation of probation would be the fact that you didn't report. Now, you, without testifying, gave me an explanation. So I'm going to ask you to raise your right hand, and I'm going to have you placed under oath.
Thank you. Yes, ma'am.
All right. Why did you not report when you pled out on that original charge of escape?
Thank you. Okay. 11/21/23. That's when the escape came. So I served from 4/23/24 to 11/23, from 4/23/24 to I was released on 12/23/24. I didn't report because it was a misappropriation paperwork. I had to serve 9 months. I had to serve 11/29 on an escape at 11 months 29 at 75% is 9 months jail time. So when I went pro se, I had 48 days from 9/22/23, and then I served 8 months straight. So when I served my 8 months, I'm assuming when when Matthew T. Mitchell, my elbow counsel, when he said, I'll let you go on the vandalisms. I had got indicted for 2 vandalisms. So he said, I would let you go home. Continuance contingent upon you signing that you
Your
were taking.
lawyer said you could go home?
That's the only way I could go probation. So when I signed for her probation, it was a suspended sentence to probation. It makes sense. So I'd already served. In my mind, I'm thinking I'd already served the escape. So I didn't get 2 escapes. I only got 1 escape. So
All right, that's fine.
Yes, sir.
Does the state have anything else to input in this?
So I had 8.
You be quiet. When
Yes,
she
sir.
talks,
I'm
you
so
be
sorry.
quiet. Well, Mr. Brooks, I'm going to give you a chance to report and see whether or not you do or don't.
Thank you, Judge.
I find that you are in guilty, technically a violation of your probation for failure to report. I understand what your explanation is. The new charge that was the basis for it obviously can't be considered because it's been dismissed, but you
Amen.
understand that could be brought back. I'm going to reinstate you to active probation, extend your probation for a period of 6 months, and I'm going to set a review date for this case in front of me on September the 29th.
So I get to come in regular clothes?
You're going to get regular clothes?
No, I'm saying, do I get out today?
Well, as far as I'm concerned, I'm releasing you back to probation. So you should be released as soon as the paperwork clears. And then, but you understand, see that lady over there?
I know
You have
exactly
got
where
to-
Mid-Cumberland is.
Okay. One thing that you're going to benefit from in the future, because I fully expect we're going to see you again, if
Yes,
not
sir.
before September. When you're in court and someone else is talking, you just wait till your turn, okay? It's like when you're a child and you're at the dinner table and you're told you want to speak over your parents. Well, in the court, it's the same way. You can't talk while I'm talking. You can't talk while the DA's talking. You wait your turn. You'll be given every opportunity to say what you want to say. But here's the reason that I'm doing this today is because I'm giving you an opportunity to see how you report. Once you report, and between now and September, if you do everything you're supposed to do, stay out of trouble, then we'll take a look at you on that September 29th day to see whether or not there's any need to keep you on the docket, okay? See her? You need to talk to him today? All right.
Amen. Thank you, Judge.
All right,
You done?
we're done. (2022) CR 390, State versus Josie Harrison.
Your Honor, for Ms. Harrison, she was furloughed pending sentencing to Mending Hearts. She successfully completed that program and has remained on furlough until today. The agreement to resolve this is for her to be transferred to community corrections. And I'm writing up the paperwork for that right now.
All right. Have just a moment, please.
Sir.
Yeah, thank you. All right, she was, she admitted her probation violation, so she's already been found guilty of that. And it was furloughed to Mending Hearts, reset for sentencing for today. And by my understanding is that there's an agreement that she be reinstated to probation. Is that correct?
Only she'll be transferred to community corrections, Your Honor.
I'm sorry. Reinstated to probation and transferred to community correction.
That's
All right,
correct.
Ms. Harrison, raise your right hand. Let's place you under oath.
Yes.
Thank you. State your full name for the record.
Josie Harrison.
Ms. Harrison, you're here today for sentencing on the violation of probation that you admitted to. Do you understand that you have a right to a hearing in this court where the state would be required to put on evidence about what should be happening in your case? You would be allowed to put on evidence if you chose to do so, and you would have the right to an attorney to represent you at that hearing, as well as the right to appeal whatever I did in your case if we had that sentencing hearing. Do you understand that?
Yes, sir.
You understand that by this agreement, you are waiving your right to that sentencing hearing, and all that's going to happen is I'm going to reinstate you to probation, transfer you to community corrections, which is a much more intensive probation than what you were on before. Do you understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilt? I'm sorry, do you want to waive your right to the sentencing hearing and go according to this agreement?
Yes, sir.
Then upon your plea, I find that you have already been found guilty of violation of probation. I will now transfer you to community corrections and reinstate you to probation with community corrections for the balance of your sentence. Good luck to you.
Thank you, Your Honor.
Ready? Is this Mr. Cathy? All right. William Darrell Cathy is public defender.
Yes, sir. This one's for hearing, Your Honor.
All right, I'm ready for the hearing. State ready.
If I may, Your Honor, I'd like to review the court's file before the hearing. This could be addressed later.
We'll put it on a second call for you to review the court's file. Do you have any problems with transferring that to Mr. Talbot? I will, on these second calls that are being transferred, if we are not able to reach anything today, it will be passed to Thursday of this week. So whatever we don't get to today will be on Thursday. Step back, Mr. Cathy. On page 8, State versus Adriana M. Henson. This is a hearing on the status of payments. So it's shown that she's outstanding. Is there a bond on that one? All right, be a capious for the defendant, hold without bond. Pardon? She has been taken into custody. Okay, well then we'll bring her out whenever they, we'll show she's in jail and we'll bring her out at the appropriate time. As soon as you have another inmate ready, bring them out. I'm just going through those that are not in jail. We're ready. Christie's on page 3. All right, this is a probation violation hearing. Mr. Christie, I show that you are representing yourself. Is that correct?
I guess so, yes. I thought this was the hearing Friday, but it's okay.
You know, you have the right to an attorney to represent you, and you will have the right to have one appointed since you're in custody if you want one.
Yes, I need one.
You do need one?
Yes, sir.
All right, then I'm going to appoint the public defender to represent you, Mr. Christie. And here's a copy of that charge, Mr. Howard. There's more than one or not. All right. You now have a lawyer. Talk to your lawyer. We'll come back to you.
Yes, sir. Thank you.
Looks like the next case that's not in jail would be 2020 CR 81 State versus Aaron James Knox Howes.
For Mr. House, he completed the program at Men of Valor. He has a copy of his certificate. We have an agreement, Your Honor, to disposition in this case. Mr. Howes will admit the violation, he waives his hearing. He'll be reinstated to probation with additional conditions, Your Honor. Those are no IoT reporting. We'll have a minimum of monthly drug screens, zero tolerance for those drug screens, and enhanced reporting for at least 1 year.
All right, he's previously been found guilty of violation probation back in March 2024, and the sentencing was reserved for him to complete that Men of Valor furlough. So, all right, let's have Mr. Howes raise your right hand and be placed under oath.
I do.
State your full name for the record.
Aaron James Knox House.
Mr. Howes, you are here today on this sentencing on the violation of probation that you were previously found guilty of back in March. And you understand that at the sentencing hearing, you would have the right to put on proof and have the state would be able to put on proof, and I would hear from both sides. You would have the right to have a lawyer, and then I would make the decision about what's appropriate sentence would be. Do you understand that?
Yes, sir.
You understand that if I entered a sentence you disagree with, you would have the right to appeal that sentence to the Court of Criminal Appeals, and a lawyer help you with that appeal. Do you understand that?
Yes, sir.
You understand that by entering into this agreement, you're waiving your right to that sentencing hearing and to the appeal. All I'm going to do is to approve what you and your lawyer have worked out.
Yes, sir.
And this is based on the fact that you've done well in rehabilitation and successfully completed that. You understand that?
Yes, sir.
You understand everything I've explained to you?
I do.
You want to waive your sentencing hearing and enter in according to this agreement?
I do.
Then upon your plea, I find that you are in fact guilty of violation of probation as previously found in March of 2024. I order that you be reinstated to probation based upon your successful completion of the furlough. You're to have no IoT reporting, a minimum of monthly drug screens, a zero tolerance, and enhanced reporting for at least 1 year. What that means is zero tolerance means one positive drug screen and you're going to jail. You understand that?
Yes, sir.
All right. I think you've done well, so I applaud the fact that you've been successful thus far, but you still got a ways to go.
Yes, sir.
All right.
Thank you.
Good luck to you.
Thank you, Your Honor.
You ready? All right, Ms. Henson, you're here today on a probation violation. Originally, that probation violation was for non-payment of fines and costs, but I think it's now been an amended charge. That amended charge is that you have tested positive for amphetamines and methamphetamines on or about May the 1st of 2025. You have the right to an attorney. Do you wish to have a lawyer represent you?
Please.
All right, public defender will be appointed.
Acknowledge receipt of a copy of the affidavit, waive formal reading of the same, and enter a plea of not guilty.
Plea of not guilty is entered, set for hearing June 30th. Okay. All right, we're waiting for the next inmate. 2023 CR 21 State versus John Robert Hunt. That's Mr. Waynick's case. Mr. Hunt, your lawyer is on his way, so we'll come back to you. Or at least he's supposed to be on his way. 2023 CR 169 State versus Jeremy J. Jaco. Mr. Sanders. All right, I'll put it on a second call. (2024) CR 208 State versus Anthony James Justice. That is Mr. Spratt. Who is? And we know where Mr. Baker went. Have a seat. We'll come back to you later in the day. Anybody from that firm present? Because the next case is Mr. Atchison's case. All right, 2022 CR 113, State versus Matthew Killebrew. Killebrew, your lawyer is Mark Atchison. Have you talked to him today?
I haven't seen Mr. Atchison. I've seen Mr. Baker, but not Mr. Atchison.
I'll come back to you on the second call. Thank you.
Okay.
Twenty 21, State versus Rebecca Sue Laciani. Ms. Laciani, you were represented by Kelly Jackson Smith. Is that correct? Oh, this is just for successful completion of the community correct. All right. You have an order? How do you pronounce your last name?
Lacion.
Ms. Lacion, you are here today because you have successfully completed the first stage of your probation, that being the community corrections. I have been handed an order that will transfer you to regular probation. So you're to be applauded for successfully completed the community corrections program, but you still have a ways to go. So you understand that? You will be on regular probation now?
Yes, Your Honor.
All right, and I will sign the order transferring you to regular probation. Good luck to you. I hope you
Thank you, sir.
complete that probation as well. We're ready, anybody? All right, and page 22, State versus Tanya K. Ledford will be at 1:30 today. 2021 CR 173, State versus Donald Keith Lee.
This is for a review of payments. When was the last payment? Your Honor, he most recently made a payment of $100 to the court clerk's office, showing May 9. And
Do we have a
it's like he's
put out? He is paying monthly. Looks like we just need to set a further review down the road, so. Give us a date 6 months from now, which would be November. You got a November VOP day. All right, we're going to reset a review November 24th to let you continue making those regular payments, okay? Thank you.
Your Honor.
I'm ready. I'm sorry, what was the name?
Honor, Mr. Cooper has applied for drug court, recovery court. I think a reset would be in order. You just asked him. Okay, thank you.
All right, so what are we doing with him?
Your Honor, I think a reset to the next VOP day would be appropriate because he's applied to
All
recovery.
right, he's applied for recovery court, so we'll move it to 6:30, June 30th. Twenty 2023 CR 83, State versus Josiah Lewis. Final bond forfeiture. Right. They have not requested an extension. Be a final forfeiture entered. Booby's bonding. All right. This is Keaton Lane Dial.
Your Honor, Mr. Dial has a set of charges in White Bluff Court that are pending. So I would ask that this be reset to the next VOP.
June 30th. On page 16, 2023 CR 356, State versus Joanne Taylor McElhaney. Joanne Taylor McElhaney, that's the public defender.
Have neither seen nor heard from Ms. McElhaney. She has not responded.
Does she have a bond?
Joanne McElhaney.
All right, there'll be a capias for the defendant, hold for a hearing. (2022) CR 24, State versus Michael DeMario McHenry, public defender.
At Cross Style in Lebanon, he's making good progress there. I have a letter from the facility giving us a status update.
Sorry.
He's projected to graduate the program, Your Honor, in February 2026.
He's projected to graduate in February. Let's just put him on the September VOP day for a follow-up to make sure everything's going well. September the 29th.
Sir.
I'm going to file this letter from his rehabilitation in his file. All right. Mr. Flanagan is on his way, so we're going to have to put you on the second call. We'll come back to you when your lawyer's here.
All right, yes, sir.
Thank you. Page 17, State of Tennessee versus Joey Adarez Nixon, 2021 CR 365. This is a hearing on the status of payments. Yeah, you still got quite a bit of money owing, but you've been making regular payments, so let's just put him into the January. Did we get out of January VOP there yet? We're going to give you till January 26th to give you quite a bit of time. Just make those regular payments like you're doing. You should be okay, all right? All right, we'll see you in January, January 26th. Okay. All right, we're ready. All right, Mr. Robert Walter Isley, Mr. Spratt represents you, and anyone here from Mr. Spratt? As of both a violation of probation, and it's indicated he's going to enter a plea under a criminal information. Yeah. All right, I've been handed a document indicating that
Judge, I believe the state's gonna amend this to an felony DUI. Pay a $3,000 fine, sentenced to
2 years Tennessee Department of Corrections, suspended after 150 days, credit for time served, $3,000 fine and cost, loss of driver's license for 8 years, eligible for restricted license with interlock device, complete the Mothers Against Drunk Driving or DUI safety school. It will be required to make in-person reporting to probation. It will be concurrent with the case that I'm about to address, which is his probation violation. He'll be revoked to serve the balance of the sentence with credit for time served. All right, Mr. Isley, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Robert Walter Isley.
Mr. Isley, you're here today on two different types of charges, so I want to cover them both with you to make sure you understand your rights in each. On your probation violation, you understand you have a right to necessarily have a lawyer represent you and have one appointed as we've done, or I don't know if Mr. Spratt was appointed or retained, but you understand you would have the right to a lawyer and have one appointed if you could not afford your own.
Yes.
You understand you would have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation. You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by pleading guilty, you're waiving your right to a hearing and to the appeal on your probation violation, and I will then revoke you to serve that sentence with credit for all your time.
Yes.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a hearing and enter a plea of guilty according to that understanding?
Yes, sir.
And upon your plea of guilty to probation violation, I find you guilty, order that you be revoked to serve your sentence with credit for time served. The document I've been handed gives all of your credit that's set forth on it. All right, in the next case, it's a new charge that you're traveling under what we call a criminal information. I want to explain to you that every person charged with a crime and that carries the possibility of incarceration has the right to have their case reviewed by the independent body called the grand jury of this county. The grand jury is an independent body that meets in secret, and they consider the evidence and they determine whether there's enough probable cause for a charge to be returned against someone. Then that body would have the right to review your charges and determine whether or not you should even be charged. You have the right to waive that to expedite the entry of a disposition in your case. And what I've been handed is the document that allows you to waive the grand jury's intervention and to proceed on the criminal information. Do you understand that?
Yes.
You understand by entering this criminal information, you're waiving your right to have the grand jury review your case.
Yes.
Is that what you wish to do?
Yes, sir.
All right. You understand that you're charged now with going to be an amended charge of driving under the influence, fourth offense, a Class E felony, and that you understand that what you're charged with, and have you and Mr. Baker or Mr. Spratt talk this over and discuss what the range of punishment is you're facing, as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere or no contest. What that means is you're not going to admit you did anything, but you're not going to contest the state's evidence. And as a result, they will give me the facts that will support this case, and I will then find you guilty according to those facts, according to this agreement. Do you understand that? Okay, I've got to have you answer yes or no.
Yes, sir. Sorry.
Do you understand that you have the right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that at trial, you would have the right to have a lawyer, to have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, plus you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
You understand that by entering this plea of nola contendere or no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes.
You understand that's going to result in a felony conviction that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. I've been handed a document called the Notice of DUI Punishment that sets forth all of the enhancement provisions of our laws regarding DUI. Every DUI conviction carries a greater conviction for the next one. You understand that?
Yes, sir.
Is that your signature on that document?
Yes, it is.
Do you and Mr. Spratt go over this document? Do you fully understand the nature of the laws regarding the enhancement provisions of the law?
Yes, I do.
Any questions about that at all?
No, sir.
All right. Do you understand everything I've explained to you thus far?
Yes, sir.
You understand that this conviction will be on your record in the future to make more severe the punishment you receive the next go-round?
Yes, sir.
Is your decision to plead guilt, no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand that I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty of this charge?
Yes, sir.
Now I want you to step aside and let Mr. Stevens, I have to remember, I started to call you public defender, that's what, the hesitation. So General Stevens, if you'll give me the factual basis for this, please.
Yes, Your Honor. The state would intend to show at trial that on or around September the 17th, 2023, at approximately 5:30 in the morning, Officer Devontae Sanders with Dixon Police responded to a call for service for a suspicious vehicle at Speedway off Highway 46 South in Dixon County. The caller stated 2 males had been asleep in a vehicle for 2 hours prior to the call. Officer Sanders did respond and observed the driver of the vehicle, the defendant, with a smell of alcohol on his person and showing signs of impairment while being in control of the vehicle. The defendant admitted he, quote, wasn't good to drive. He exhibited all 6 clues for the horizontal gaze nystagmus test before refusing the walk and turn in one-leg stand, resulting in automatic failures for both of the latter. He additionally refused to provide a sample for chemical testing where a warrant was applied for and obtained. A sample of his blood provided he had a BAC of .237, well above the per se amount. This is the defendant's 5th DUI, and as part of this agreement is being amended to a 4th, as you've already noted.
Mr. Isley, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be?
Yes.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes.
Feel like Mr. Spratt has done a good job of representing you competently?
Yes.
Mr. Baker, standing for Mr. Spratt, do you know of any reason you should not enter this plea?
I'm aware of it.
Anything further from the state? And Robert W. Isley, in docket number 2025 CR 121, upon your plea to the amended charge of driving under the influence of an intoxicant, 4th offense, I find you guilty, sentence you to 2 years, Tennessee Department of Corrections. That will be suspended after you serve 150 days with credit for time served. You're ordered to pay a $3,000 fine and court costs. Your loss of driver's license will be for 8 years. You are eligible for a restricted driver's license with an interlock device. You must complete the Mothers Against Drunk Driving or VIP or DUI school, Mothers Against Drunk Driving Victim Impact Panel or DUI school. You will be required to make in-person reporting to probation, and this will be concurrent with a prior case of 2020 CR 338. That's the judgment of the court. Thank you. All right, Cody Allen Lee Francis. Mr. Waynick's case. Good morning, Mr. Waynick.
Morning. Judge, there should have been a plea petition filed that would.
All right, I'm moving as quickly as I can, and the clerk's trying to keep up, so give us a moment.
Oh, hurry.
All right. All right, I've been handed a document indicating that in Mr. Francis's case, he will be entering a plea of 2022 CR 30, plea of no contest or nolo contendere to count 2 of the indictment, possession of heroin for resale, and he will receive a sentence of 10 years to serve in the Tennessee Department of Corrections as a range 1 offender, $2,000 fine and costs. Count 10, possession of a weapon by a convicted felon. He will receive a sentence of 10 years to serve as a range 1 offender concurrent to count 2, forfeit the weapon. He will pay court costs on counts 2 and 10. Both counts are concurrent with his sentence in Hickman County Circuit Court. Count 7 of that indictment is dismissed as a part of the agreement. And then there are multiple days that he gets credit for set forth on this document. Mr. Francis, raise your right hand. Let's place you under oath. State your full name for the record.
Cody Allen Lee Francis.
We're recording this, so Mr. Wanick wants you to step up to make sure that you can hear everything and it's recorded. You are here today on a multi-count indictment. You've heard me go over what your agreement is with the state, but have you seen or been shown a copy of those charges, and you and Mr. Wanick discuss the range of punishments you're facing as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated you want to enter a plea of, is it no contest, or nolo contendere. What that means is you're not going to admit you did anything wrong, but you are not going to contest the state's evidence when they tell me what their evidence would be at trial. And that evidence will be used by me to find you guilty. Do you understand that?
Yes, Your Honor.
You understand, however, that you have the right to plead not guilty to all charges and have a speedy and public trial by jury.
Yes, Your Honor.
Do you understand that if you went to trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, Your Honor.
Do you understand that at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, Your Honor.
Do you understand you would be presumed to be innocent at trial? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I will do is to approve what your lawyers worked out.
Yes, Your Honor.
But you understand that's going to result in 2 different convictions, and those convictions will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, Your Honor.
You also understand that I'm sentencing you to 10 years.
Yes,
That sentence is what the Department of Corrections is being given by this court. How much of that sentence that you have to serve is up to the Department of Corrections. Those good credits and things other than your release eligibility date, good time credits or all of that's not a part of this agreement. You will get credit for time served, but you understand that it's up to the department how much you have to serve.
Yes, Your
You
Honor.
understand everything I've explained to you.
Yes, Your Honor.
And you understand this conviction is going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, Your Honor.
Do you still wish to plead no contest according to this agreement?
Yes, Your Honor.
Is your decision to plead no contest today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No, Your Honor.
Do you understand I can't accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of this charge?
Yes, Your Honor.
And I want you to listen as the state tells me what their evidence would be. In general, if you want to just turn that microphone on, as you can give us that information from your desk. Listen as the state tells me what their evidence would be if this case went to trial.
Judge, if this case had gone to trial, the state would have put on evidence to show that back on January 18th of 2022, agents with the Drug Task Force were executing a search warrant at a home over on Railroad Street here in Dixon. And upon arrival at the home, Mr. Bolstad, along with Mr. Francis, were seen in a vehicle with Plainview drugs in Mr. Bolstad's lap. They then detained both Mr. Bolstad and Mr. Francis, and Mr. Francis was in possession of a revolver as well as 2.5 grams of heroin, and Mr. Francis is a convicted felon and was not allowed to have a gun.
All right, I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if this case went to trial.
Yes, Your Honor.
Still wish to plead no contest according to this agreement.
Yes, Your
Are
Honor.
you satisfied with your attorney's services?
Yes, Your
I feel
Honor.
like Mr. Wanick has done a good job of representing you competently.
Yes, he has.
Mr. Wanick, do you know of any reason he should not enter this plea?
I do not.
Anything further from the state? and Cody Allen Francis in docket number 2022 CR 30 upon your plea of no contest or nolo contendere to count 2. I find you guilty of possession of heroin for resale. Sentence you to 10 years in the Tennessee Department of Corrections to serve as a range 1 offender. Order that you pay a $2,000 fine. Count 2, you're found guilty, sentenced to 10 years to serve in the Department of Corrections as a range 1 offender. That will be served concurrently to count 2. The weapon is forfeited. You are ordered to pay court costs on counts 2 and 10. Count 7 is dismissed. Those counts are concurrent with each other and concurrent with your sentence in Hickman County Circuit Court. You'll get credit for time served according to the document that's set out. Thank you.
Surgery for? To fix my deviated septums. The first surgery, they went in and they cleaned out my sinus cavities. Then the second one, they went in and they cut me open here, pulled this open, pulled the tissue from my skull and put it into my nose to regenerate my nose, my deviated septum. And I didn't know it was gonna take a year to heal.
Seated. All right, this is 21-1198, Doug, push on, violation of community control violations. Tested positive for methamphetamine May 8th, screen, you understand that charge? Yes. And May 16th also tested positive for meth, you understand that charge? I do. You don't understand it? I said I do. Oh, you do, okay. Ms. Novotny, what's you want to do?
Your Honor, today we would like to waive our probable cause and final hearing and plead guilty to the violations.
Is that what you want to do? I do, sir. What's your plea to those violations? Guilty. All right, I'll accept your guilty plea and find you guilty. So what's going on? I had a stumble, for the last 23 months. I've been clean. And I had a couple surgeries on my nose, and this last surgery really got to me, and I had a stumble, I had a bunch of perks, and I was eating them as doctors prescribed, and just towards the end, I had a lot of complications. They were pulling stitches out, and I screwed up, and I got high. I almost had 2 years clean. I was 8 days away from 2 years clean, Your Honor, and I stumbled. And being an addict, it's hard. It really was. I got an inch and I took a mile, and I take accountability for my actions. I've, in this last 23 months that I've been clean, I've learned a lot about myself, learned a lot about the addiction, and I got complacent and I wasn't vigilant on what was going on in my life. I was helping more people than I was helping myself, and I took a little bit too much on, and I stumbled and I went backwards. What was the surgery for? To fix my deviated septums. The first surgery, they went in and they cleaned out my sinus cavities. Then the second one, they went in and they cut me open here, pulled this open, pulled the tissue from my skull and put it into my nose to regenerate my nose, my deviated septum. And I didn't know it was gonna take a year to heal. And I still have stitches in that gotta come out. There's still a lot of complications, but I didn't know it was gonna take a year to heal. They told me, after the first 2 months I'd be okay, and that's not the case. There's still pulling stitches out, there's still blood coming out, there's, still a lot of factors being played in. So. What did they prescribe for you? Percocet, Tramadol, Xanax.
And,
You know, and my people were holding on to them, and I needed them, and I just got out of control at the end. Like I said, I ran out and I just got high. And I'm still in pain, but you know what? The Tylenol seems to be working now. They prescribed me 120 Tylenol a month now, and I'm just using straight Tylenol. There's no more of the Tramadol or Percocet.
before you had the surgery, did you tell them what your
Yes, they knew I was.
history was?
Yes.
Okay.
But they said with the amount of pain that I was in, that I could not, my body could not react unless I had that in me.
Okay, so when did you determine you were gonna have that surgery? You had it in November, the first one?
November was the first one, I believe, and then the second one was 2 months later, so January, I believe.
Okay, so, but in advance of November, when did you make the decision you were gonna have that surgery?
A month later, he told me I was gonna have the surgery. It had to be back to back, the way the surgeries went.
No. You had the first one in November, right?
Yeah,
Okay, when did you start going to the doctor and then you figured out you needed surgery in November?
a month prior to that,
All right.
October.
What caused you to do that? What was going on with your,
My sinus infections, I was getting severe sinus infections, and they said the only way to treat the sinus infections was to have these surgeries.
okay, so what do they say? When's the last time you went to the doctor for that?
A month ago? A month ago.
Okay, and what did he tell you?
That it's gonna be a year for it to fully heal, and I have to go back every other month to have them keep going in there and checking it's still healing, right?
How do they do that?
Well, they take this camera and they shove it up in there, and then
In your nose?
oh yeah, and they go all around in there, and it's some severe pain. Well, the last time they did it, they used a spray, and it actually sent me into almost into a relapse right then and there, because it made my whole face numb. And the reason I quit doing cocaine and all the drugs up my nose was because of how my face would go numb. And he shot this shit in there, the stuff in there, and it made me just, it blurred my head a lot. And if it wasn't for that woman there being with me and getting me back to my sponsor, I would have probably relapsed way before that.
All right, so are they gonna use the spray anymore?
No, they're not allowed to use that ever again. We made that official.
Okay.
Ever again.
All right, so then what else you've been, besides all that stuff, what have you been doing the last couple of years?
So, I've been a secretary of the Fellowship of NA at Magic Moon for a whole year. I took on that role. I made the whole year.
Where's that one at?
That is at Menor Lakeshore, and right in front of the Headlands, right outside the Menor Headlands, there's that white church. If you're coming out of the Headlands on Lakeshore, I've been a secretary there for a year. I've been picking up guys from treatment centers from here all the way to Cleveland and back, taking guys to meetings. I've been chairperson for a whole year, at different meetings for a whole year. I believe in this fellowship, and I believe I screwed up, and that's why I'm here taking accountability for it. It's no one else's fault. I stumbled, and I have to live with what I did. You know, what really hurts me the most is I was 8 days away from finally accomplishing getting my 2-year point. I've never had nothing like that in my life. My 1 year felt amazing. You know, you guys let me go to, I went to West Virginia, and I've never seen something so amazing in my life. There were 1,600 of us addicts in a Serenity Circle, and we all did the Serenity Prayer. I've never felt nothing. The love that you get from going to these conferences or from these different fellowship, like meeting different addicts in different areas, is truly amazing. So the first 2 years that I've been on probation, I screwed up. I looked at probation as a failure. Now I look at probation as accountability for me. Because every time I go in there, I know I'm held accountable for my actions. And I truly believe in it. And I got my daughter back. You know, my daughter, me and her have got such a closer bond because of this. She goes every Friday with me to my meeting. She's there every Friday, make sure we go to the meeting together. You know, it's truly amazing. I never had that before with my daughter.
What are you doing work-wise?
I am slammed with work right now. Me and my stepfather have our own company, Man's Construction, me and Butch. And then I independently go to 2 other guys during the week. When they get their loads of concrete, I go and help finish them off. I actually took a role on as helping a friend I worked for 20 years ago, cooking for him at his restaurant / little bar. It's on the corner of Lake Shore and Lawson Nation. I actually am helping them right now. We just took second in the Silver Spoon Award and first for the best chicken wings in Northeastern Ohio. So I do that at night every now and then just to get them over the hump when their guys call off. And I'm busy right now. I'm trying to take over my daughter's mother's house. She offered me a deal right before I got arrested, saying that she would like me to sign a contract with her and I would take over her house and she's gonna get another one. So I have my own place so I don't have to live with my parents no more. Like, I'm doing all the right steps. Literally I had a stumble. I had to misjudge a character and I misjudged my vigilance on my own well-being.
So are you telling me that it was, that letting up on your vigilance was separate from the surgery medication? Or was it all one and the same?
It's all one and the same.
So how do you correct this?
Well, how we're gonna correct it is I'm gonna go back to my 3 to 4 meetings a week, sometimes 5 if I get more time. Me and my sponsor are going back for starting over on my steps. And I'm gonna call him every day like I used to do. You know, I'm starting back at the basics. I have to start all over again, you know, and it's hard, but I can't beat myself up over it no more. I was hitting myself with a brick when I first did this. Now I have to understand I'm an addict and I'm gonna be an addict the rest of my life. The only way to correct it is to get to these meetings, to be around my clean fellowship. Like, that's why I'm in NA. NA is all about all the addictions. It's not just about one. I am for more than just an addict. I've had problems with sex addicts. I'm an addict, okay? Just not with drugs. So that's why I'm in the NA fellowship. And I need to be around my NA family. They're the only ones who's helped me get through this the last 23 months.
How much you weigh now?
170?
How much did you weigh before?
145?
A few years ago.
Oh, like 140? I was horrible. I put on 30 pounds. Dude, I had my teeth redone. I got new teeth. I had a knee surgery. Like, I took all the right steps. Like, my teeth were major. That was huge for me. Now I actually have teeth. Yeah, I looked like a little chicken wing when I came in here.
Ms. Novotny?
Your Honor, just to reiterate, it seems like the stepping stone that kind of caused him leading here to be today is his struggle with the recovery process with the deviated septum. I know I put a lot of thinking in regard to maintaining his path to sobriety. I know he's going to remain diligent with that respect. He's even told me that he wants to start off with square one, just like he's told you today. He wants to restart the way he did 2 years ago as well. Your Honor, with that, he is working, he's busy, he's keeping himself preoccupied with working, as he's told you, with Man's Construction. Additionally, he's an independent contractor on the side to help finish with paving concrete, or pouring concrete, excuse me. And additionally, he does helping out a friend too for another job at night, being a cook, called Knocks Off Grub and Pub. I know what means a lot to him the most too is his reconnection with his relationship with his daughter. I know he informed me too, a big thing for him is that she does, her birthday's coming up in July, and he doesn't want to mess that up for her as well. I know that means near and dear to him to maintain that relationship he has right now. I know in the back of this courtroom shows the support he has, not only from family and friends, but support systems that he has had an NA, and I know the letters that we've submitted on his behalf also show that. So we're just asking for any leniency and keep him on community control, Your Honor.
Okay, Kaylee, what's he got in on this one?
Probation violation of 13
All right, I'm gonna keep you on community control. You got, another 363 days left. 13 days in the jail with credit for 13. Go back to your NA at least 3 a week, plus a sponsor, and then all the things I told you to do that you still are under the obligation to do back from July of '23. Those are still in effect. Got it?
Yes, sir.
All right, time to get back on the horse.
Thank you, sir.
Anything else?
No, Your Honor, thank
Ms.
you.
Warren, anything else?
No, Your Honor, thank you.
All right. Okay, Doug, go do what you're supposed to do.
Thank you, Your Honor.
All right.